with your lordship observation, but my lord, it was I received. I've seen the notification way too late, my lord.
What?
I seen the notification. It was late by the time I've seen the notification, my lord. It was bad on my part. I accept that, my lord. But
Next time I'm not going to permit.
absolutely, my lord. I will.
Once the notification has been issued under the directions of the Chief Justice, I have no authority to.
I humbly beg to apologize, my lord. Just for this time, my lord.
You are Mr.
Please, my lord.
Please, in a
Private respondent, no.
fine.
Matter will fix on 2nd March, my lord. And for the petition.
You are for petitioner. Third MS.
Ever.
For a learned counsel for petitioner. On request made by B. Sinha, the counsel for the respond number 5. List the matter on
2nd March.
2nd March. 2nd week of March.
On the 2nd of March.
On
You
2nd.
want it on the 2nd?
No, she's praying for that. On the 2nd of March.
Okay.
May it please your lordship. Lordship, I beg to list one content case for orders. 3rd March.
3rd March.
Obliged.
Here, please, your lordship. I beg to mention item number 14 on behalf of M. Choikia, my lord. She is not well today. So matter will fix on 2nd March, my lord.
It's the same problem now that you are going against the notification. Have you informed the other side? Have you informed the other side?
Yes, ma'am.
Today I'm giving you some concession. From tomorrow, there will be no concession with regard to our activity.
14.
You have to give 1 day notice, prior notice. On request made on behalf of MS and Chakin, counsel for petition. Is the matter after 1 week, 2 weeks?
On 2nd March.
2nd.
I'm from BTC, madam.
2nd March.
Thursday. Thursday, no? Because
Sorry, ma'am.
May I please, your lordship? Your lordship, I pray for listing of a matter, your lordship, for admission, your lordship, on the 28th of February, your lordship.
That is difficult. We can have it on 9th March.
9 March. Yes, much obliged, your lordship.
May I please, your lordship? I beg to mention the listing for admission, lordship. Matter regarding lordship, the pension matter, lordship. 27/1/2023 leftover, lordship. Please the matter list on Friday, lordship.
10th March.
10 March, lordship. I am not available. I am out of station, lordship.
So after 10th, give a date.
Before, lordship.
13th, you are there?
Lordship.
13th March.
Before, lordship, 10.
All dates are booked now. There's a long holiday there.
Lordship, 27 February, lordship.
2nd, okay, 2nd.
2nd March. May it please, your lordship. Lordship, I pray for listing of an IA for implement. IA for implement, it was filed on 8/2/2023 and the IA has already been numbered out.
Okay,
Tomorrow or day after tomorrow.
no, next week.
It is IA for implement, your lordship. For the first time it is come. Motion. And it was filed on 8th of February.
Monday, 27th.
Obliged, lordship. May it please, your lordship. May I pray for listing of a repetition on 28th, my lord.
28th is a hearing date.
Hearing day, my lord.
Must be. My lord, I am praying for listing a contempt matter, my lord. After a week.
Yeah, after 1 week. First week of March.
First, my lord, first.
First week.
First week, my lord, date, my lord. Second.
My lord, may I please, my lord? My lord, the petitioner before your lordship is the presently principal of Uttar Guwahati College, my lord. And while he was serving as a professor, my lord, lecturer in the college, in 2004, my lord, your lordship will find, 2004, he was awarded PhD degree, my lord. In 2004, he started, my lord, in 1997 and submitted the thesis in 2002. And my lord awarded PhD year 2004. My lord, your lordship will find, my lord, that is the award, but page 38, my lord.
Here, the affidavits and all have been filed.
Affidavit has been filed, my lord, as per direction of this honorable court, whether plagiarism is there or not.
Whether
Plagiarism is there or not in his PhD
then let us
thesis.
issue notice and we'll list it for admission hearing.
My lord, since my lord, one interim order has been passed, my lord, for
We'll
no
list it
coercive
next
action.
week.
So the matter may be taken up today itself, my lord. Since
Motions disposing like this is not proper.
Let the notice be issued, my lord.
J. Biannual Council for Petition. Issue notice. Mr.
PJ Fukan.
PG Fukan,
One
Standing
stand-
Council Party University, appears for respondent,
1 and 1,
1, 4, and 5.
1, 4, and 5. Higher education.
Lordship, as we have.
As we have in the standing council, higher education appears for respondent. Notice and respondents are complete. You file your affidavit, Guwahati University.
Affidavit, my lord.
The Guwahati University has filed its affidavit. Accordingly, list the matter for admission hearing. After a week,
After date may be fixed, my lord. Tuesday or Thursday, but it will take some time, my lord.
Tuesday or Thursday. 2nd March. Order possibly to continue till the next.
Most of them. Okay.
My lord,
Yes.
may I please, your lordship. Item 2 may be taken up first, lordship, which is my learned friend already filed affidavit in that case, lordship. I have given some list of dates, lordship, events in the instant case, lordship, which I supplied,
List of dates.
lordship.
Yes.
My lord, here in this case regarding the starting of B Pharma and D Pharma course of the petitioner institution, in which the Pharmacy Council of India already given the approval, but the NOC of the state government is required in that for B Pharma course, not for D Pharma course, for which lordship this honorable court in the above matter was pleased to issue notice, then also with an interim protection that no adverse action to be taken. Kindly peruse the order dated 17/3/2020, lordship.
17.
3/2020.
Yes. Yes.
Lordship, just I am coming one by one, lordship, the annexures of the instant petition, lordship. Petitioner applied for NOC, page 21, lordship, annexure 1.
Page 21.
Lordship,
Annexure 1.
annexure 1 is the, lordship, sorry, lordship, it is it is 28, lordship, page 28, wrongly, sorry, lordship, page 28.
1.
I have petitioner submitted an application on 31/12/2018, lordship. Sorry, oh, sorry. Annexure 1, page 20, lordship, is the approval given by the Pharmacy Council of PCI, Lordship, page 21. My name is Hamad College of Pharmacy, Dental, Medical Science, Lordship, serial number 2, approval for 2019 for conduct of so and so, Lordship. Then page 27, annexure 4, Lordship, is the guideline of Pharmacy Council of India, Lordship, PCI. Lordship, got it, Lordship. Here is the, for D Pharma course, no admission shall be without submission of the consent of appellation or examining authority. No approval is required for D Pharma course. NOC is required for D Pharma course. Here is the in the guideline. But regarding B Pharma course, it was further decided that the above approval is subject to the submission of the consent of appellation of the examining authority and NOC or approval of the state government.
Where are you reading from?
Page 21, clause, page 21, annexure 4, Lordship.
Annexure?
Sorry, page 27.
Annexure 4.
Annexure 4.
Yes.
That is the guideline, Lordship, of the Pharmacy Council of India.
Yes.
Lordship, the above is subject to submission of the consent of appellation of the examining authority and NOC approval of the state government.
For B Pharma.
B Pharma, Lordship. D Pharma, no NOC is required from the state government.
D means diploma
Diploma,
and B means
Bachelor of Pharmacy, Lordship. Then page 29, Lordship, annexure 6. Letter issued by the Deputy Secretary to the Government of Assam. A committee was constituted for inspection of the as per PCI guideline for the petitioner's institution. Then next page, Lordship, a committee was constituted. Page 30, annexure 7. That committee, Lordship, have not inspected. Then again, another committee, page 31, Lordship. Again, another committee was constituted on 7/9/2019 for inspection. You are requested kindly inspect the institution for starting opening of B Pharma, D Pharma courses and submit an inspection report to this directorate within 10 days, Lordship. Then, Lordship, while they are not processing, Lordship, the petitioner approached this honorable court, page 32. And this honorable court was pleased to pass an order. Operative portion of the order, Lordship, page 34. May I read, Lordship, third paragraph, page 34. After hearing the parties perusing the relevant materials placed before this court, noted above, and as the respondent number has already directed the DME Assam to submit the inspection report about the petitioner's college regarding its feasibility to start B Pharma, D Pharma courses for which PCI respondent number 2 has already given its approval for the session 2019-20. It is directed that the Director of Medical Assam shall submit its inspection report as directed by the respondent number 1 in term letter dated 4/6/19 within a period of 3 weeks from the date of the receipt of the certified copy of the order, Lordship. There is an order to submit the inspection report, Lordship, to the respondent number 1 before the respondent number 1. Then page 35, Lordship. By virtue of this honorable court's order, Lordship, the order was passed by the Director Medical Education Assam on 22/7/2019, Lordship. May I read this official order, Lordship? In cancellation of this letter so and so 97, an inspection committee is hereby constituted with the following officers. Earlier committee, Lordship, was cancelled. Then again, 3 members committee was constituted. Then third paragraph, Lordship, with reference to the government letter so and so Honorable Guwahati High Courts in WBC number so and so, all the concerned officers are requested to inspect the said institution and submit the inspection report, including comment on so and so. Dental so and so. Prerequisite norms laid down by the Pharmacy Council of India to the undersigned within 10 days, Lordship. Then, Lordship, by virtue of that letter, an inspection report was submitted, page 36, annexure 11, Lordship. Lordship, point number 2 of last paragraph, Lordship. The said institution at present meet the prerequisite norms as laid down by the PCA, and therefore NOC may be perhaps be issued to the so and so college ago for starting B Pharma and D Pharma program, Lordship. Then inspection, then again, Lordship, while they are not processing the same said letter, Lordship, then again petitioner approves this honorable court by filing the petition, Lordship, page 37. Page 38, last paragraph, Lordship. The present petition is disposed of directing the respondent to consider the said proposal. That proposal, Lordship, which I referred, page 31, Lordship, page 36, Lordship. Directing the respondent to consider the said proposal submitted by the so and so on his inspection report as contained in his communication date 7/8 and pass appropriate order so that there is no undue delay in seeking appellation from the competent authority by the petitioner. The aforesaid exercise shall be undertaken by the respondent authority as within a period of 3 weeks from the date of the receipt of the certified copy of this order. Then, Lordship, petitioner submitted the certified copies, Lordship, page 40, 41, Lordship. Then, Lordship, page 42, annexure 14. Again, that inspection report was contradicted by the Deputy Secretary. Page 42, Lordship, very important, Lordship, it is 23rd September 2019, Lordship. May I read second paragraph, Lordship? In this connection, a committee was constituted by the department's letter so and so for carrying out the inspection of the aforesaid institution. However, it has been observed that the inspection committee members mentioned in your letter so and so are not stipulated by the department. Further, it has been not specifically stated that whether all requirements have been fulfilled by the institution in all respect or not. Although this was sought by the department by its letter so and so 4/6/2019, the inspection report has merely stated that the institution almost meets the prerequisites. Then, Lordship, again, in view of the above last paragraph, Lordship, it is requested that the clarification on the aforesaid 2 aspects may be furnished to the department. Clarification was sought from the director, Lordship. Then next page, Lordship, page 43 is the clarification. He has clarified the earlier committee why they have, Lordship, in the middle portion of the second paragraph, Lordship, may kindly peruse. However, both the inspectors have expressed their inability to conduct the inspection, and accordingly this directorate partially modified the previous order and reconstituted the inspection committee letter so and so. Again, the members of the inspection committee expressed their inability. Second committee was also expressed their inability to visit, and accordingly, again the members of the inspection expressed their inability, cancelling the previous orders.
That is not required. That already report speaks.
Lordship. Then also, Lordship, here also paragraph, last paragraph number 2, Lordship. The said institution at present fulfill all the prerequisite norms as laid down by the PCI, and therefore NOC may perhaps be issued to so and so for starting B Pharma and D Pharma program, Lordship. Again, it was reiterated earlier view, Lordship. Then these are the inspection report of the up to page 51, 54. Then again, Lordship, on 9 December 2019, page 54, Lordship. Earlier, inspection report was cancelled, against a review committee was formed. Page 54, Annexure 16, Lordship. It was issued by the Deputy Secretary, Lordship. Second paragraph, may I kindly tell you.
Yes. Yep.
Then again, a committee, Lordship. In the said committee, Lordship, who are those members, Lordship? The earlier committee, genuine committee, was submitted a report, 3 members committee. Now again, only two members, Lordship. One is the Deputy Director of Medical Education, and second is the SGAS, head of the Institution of Pharmacy, Guwahati. Lordship, the earlier committee, Lordship, all are the involved with the institution, Lordship, and he is the head of the institution only. Only 2 members committee was formed, and that report was submitted by the 3 members committee. That kindly, Lordship, consider. Then, Lordship, again, while this committee was formed, review committee, Annexure 16, then the petitioner again filed writ petition. That is item number 1, Lordship. Page 55.
Yes.
'56 is the operative person, Lordship.
Yeah.
In the there also an interim order was there, Lordship. In the interim, it is provided that no adverse action taken against the petitioner in terms of the impugned order dated 9/12/2019, Lordship. That is review committee, Annexure 16, Lordship, page 54. That was restrained by this honorable court. No adverse action. Then, Lordship, in spite of having that, Lordship, page 57, Lordship. They submitted, in spite of having interim order, Lordship, they submitted an inspection report, and on the basis of that inspection report, Lordship, that was behind the back of the writ petitioner, which I have stated in my additional affidavit along with that writ petition. And then again the director, same director, Lordship, who earlier approved my NOC for NOC, and now again he is deferring his earlier opinion, Lordship. In this regard, I am of the view that required infrastructures in the proposed are grossly incomplete, and the issue of NOC cannot be considered to start so-and-so course. Then petitioner filed an additional affidavit in the above writ petition, Lordship, which was filed on 3/12/2020, Lordship, along with all photographs. And while filing the additional affidavit, this honorable court again on 9/2/2021 directed for re-inquiry of the institution lordship. 9/2/2021 in the writ petition lordship. Above writ petition.
What happened? What happened to this inspection?
Nothing they have done. They filed their additional affidavit coming with a different plea that some of the complaint cases against me is pending before the learned court below, for which by my learned friend, there are, my lord, here in this case, lordship, only 2 points are involved here, lordship. They are raising the plea that the inspection committee was constituted by the director was not in the within the approval of their head of government lordship. But subsequently, without following the honorable court's order, lordship, they again go for review inspection and submitted a report declaring that my institution is not fulfill the requisite norms. But I am clearing one thing.
Whether inspection has been done after
Against their order, my lord, the appeal was preferred by the writ petitioner. Against their order. Well, in the order passed in the present writ petition regarding that fresh inspection, well, that has not been conducted.
Why?
But that inspection.
I'm just.
Well, writ appeal was preferred against that order.
Then what happened?
That was dismissed.
No. How writ appeal? No. Etu no. Etu remanded back. Writ appeal that remanded back to the lordship. Here in this case, lordship, I am clearing one thing, lordship. Once the Pharmacy Council of India PCI found my institution is eligible and justified, fulfilling the requisite norms of the PCI, Pharmacy Council of India, accordingly they approved. Apart from that, lordship, recently.
No. I'm talking about this court's order.
Lordship, against that, lordship, we
9/2/2021. Gogoi, you are saying that an appeal was preferred against this order?
My lord, to my knowledge, yes. Well, it was preferred by the writ petitioner himself.
but that was remanded back, lordship,
Yes, it
to
was
finalize the
remanded
matter.
Hmm?
To finalize the matter, lordship.
Where is the order? Who is the order of the division bench?
But there was a writ appeal, to my knowledge.
I have to have all these facts clear.
Yes, there was a writ appeal, to my knowledge. In fact, it is the petitioner who preferred that.
Where is the order of the division bench?
My lord, lots of, in the affidavit, lots of police complaints are there against this particular institution. I will place that, my lord. In fact, my lord, it has now been placed before the CID.
So, Gogoi, after all
Yes.
this thing has happened,
Lordship.
after all this thing has happened, this court, after considering the matter, directed to have a revisit, re-inspection of the college along with the authorities of the college.
Lordship.
Correct, 9/2/2021 order.
My lord.
I want to know what happened after that.
That part, my lord.
Now, one side is saying that appeal was preferred against this order.
Yes.
If that order is, if an appeal was preferred, what order was passed in the appeal? What order did the appellate court pass?
That part, my lord, today the appeal, somebody is not with me.
Are you sure an appeal was filed?
My lord, yes, to my knowledge, my lord, the appeal was preferred.
Lordship, I'll verify, lordship, with all respect, lordship.
He was there.
Lordship, no,
appellate. He was the counsel for the appellate. My lord.
Lordship, I'll take it. And I think so far my lordship,
It was
It was
then remanded back.
remanded back to
Finalize.
finalize the entire matter, Lordship.
Let us see the.
My lord.
That I will, Lordship, I will place, Lordship.
Place it now. Only then this court can proceed.
Yes, yes.
Lordship.
Division bench order.
Number 2, number 3.
Hey, আমার বলে না। হ্যাঁ, বলে রাখছি। নামটা বলে দিবো।
Get a copy of the division bench order.
Lordship, I'll. Number 2 delay. Number present. Petitions also.
Okay, take
Lordship.
down.
Lordship,
Learned counsel for the parties submits that an appeal was filed against the order dated 9/2/2022, which was passed by this court in WBC number 1998 of 2022. Parties shall produce
at 2, Lordship.
copy of the said order. Copy of the order passed by the Honorable Division Bench by the next date fixed. Please, the matter after what.
Lordship, I pray, Lordship, at 2, Lordship, I will produce the same.
I have other matters to figure out.
Lordship, then on Thursday, Lordship, because already, Lordship, he has already some things on. Day after tomorrow, Lordship,
28. 28.
28.
Why do you have? If you file the appeal, you should have the order. I don't know.
Lordship, actually,
It was remanded back.
it was remanded back.
I will file for this.
I'll take it, Lordship. On 28, Lordship, let it be remain parted, Lordship, I pray,
No, no,
Lordship,
not part.
because
Please, Your Lordship. So this matter can be taken up for disposal. The petitioners,
Lordship, in this matter, learned advocate general will appear, Lordship, and today being out of station, Lordship will fix the matter next week, Lordship. And I think that record was also called for. But on the record, my friend Mr. N. Khatunia knows whether the record has received or not, but learned advocate general will appear in the matter. So maybe fix next week.
that is the whole problem, Lordship. This has been pending because of the inconvenience of the Advocate General civil claims. I understand when
When is he coming? Give a
Next
date.
Next week, money, any day, my lord, he's out of station.
next Tuesday,
Third
Tuesday.
MSP Borgoy, learned counsel for the petition. Mr. D.N. Chamal, learned standing counsel,
Elementary, Lordship.
elementary education, submits that the learned advocate general will be appearing in the matter. And therefore press that the matter is, would be appearing in the matter. So, accordingly, this matter, when do you want?
Date.
Give a
Tuesday?
date. convenient to the advocate
Second of
general.
March, lordship,
Second of
second of March.
Second March.
Pablo.
on this.
My lord, in this matter, we have filed today we will file affidavit, my lord. So matter may be come up on next week.
Yeah, R Islam.
Yes, sir.
First, R Islam, the counsel. Mr. D. Sharma, the standing counsel.
For secondary education department,
Secondary Education Department, substance that will be filing affidavit.
we will file affidavit today.
When?
Today, man.
Within the course of the day. Prayers allowed. List the matter.
After a week,
No. If you have affidavit, this
Yes,
defective,
yes,
no problem.
any day.
After 2 weeks.
A date may be given, my lord.
Give a date.
13. 13.
13 March. March.
No, number 13.
Lordship, the genesis of my petition is that in violation of the Rule 18 of the Assam Provincial School Service Rule, the private respondent has been selected and appointed as a regular principal of the school without any advertisement and without any interview. Lordship, the brief fact of the case is that way back in 2016, an advertisement was issued for a selection and appointment of a regular principal of DNHS School, Udarbond of Kasar district. In that selection process, a writ petitioner and the private respondent along with some other applicant participated. And finally, after interview, a merit list was prepared. Neither the writ petitioner nor the private respondent was placed in the merit list in the selection list. Lordship will find the selection list in the page 17 of my petition, Lordship. Lordship, the first one is Sumnath Det, Pratima Das, and Govindalal Chakraborty. Thereafter, the name will come. The merit list was prepared 1, 2, 3. Thereafter, the private respondent name has come, and thereafter my name has come. Sorry, my name is on serial number 3 of the second page. Thereafter, what happened, Lordship? The private respondent had challenged the recruitment process by filing a writ petition on the ground that the scheme of reservation policy was not followed, as under the Act, under the Disabilities Act 1995, some posts are to be kept reserved for the person with disabilities, and that policy was not followed. On that ground, she has filed a writ petition, and the writ petition was disposed by order dated, Lordship, on 3/2020. Lordship will find the page number. I will on 17, page number 19. Considering that the cause of action does not survive, as the new Act.
1 minute. Yes,
Then Lordship, then it was disposed, considering the cause of action does not survive as the new Act of Disabilities Act 2016 came into force. Then again, Lordship, the private respondent had filed another writ petition challenging the provision, challenging the Rule 18 of the Assam Secondary School Rule 2018. On that ground, that Rule 18 is about the scheme of reservation, but in the rule, instead of the Disabilities Act 2016, it was contained the provision of the Disabilities Act 1995. So as per that provision of the Act of 1995, she was not entitled to get benefit. Accordingly, she challenged the provision, and Lordship, finally, this petition also disposed by order dated. Lordship will find it in page number 29. Recording the submission of the state respondent that mistakenly it has wrongly printed in the Act, so it will be rectified. Accordingly, the same was rectified later on. Lordship, it is clearly, may Lordship may peruse the page number 29, then picture will be more tangible, Lordship. Lordship will find the relevant person in the page number 33, in the paragraph number 4.
Yes.
From the content of the affidavit, it has become evident that the error in service rule of 2018 has been noticed by the respondents, and an assurance has been given by the virtue of affidavit that the said error and some other error that have been kept would be corrected. The court has confronted Mr. R. Majumdar, learned counsel, appearing for the state with the fact that an advertisement has already been issued in context of Service Rule 2018. The said rule had some errors as admitted by the respondent state. What would be the justification for proceeding with the selection under rules containing apparent errors? Mr. R. Majumdar, learned counsel, representing the respondent state, has given a statement on the basis of instruction that the respondent would not proceed with the selection under the advertisement dated. This advertisement is not relevant in our case, Lordship, in view of the fact that Rule 2018 contains some error. Considering the peculiar fact and circumstances of the case, the in particular stand of the respondent state that the error in Rule 2018 would be corrected and would hereby dispose of the petition with liberty to the petitioner to file a fresh petition if the cause arises after required amendments have been made in Assam Secondary Education Provincialized Service Rule 2018. So this amendment is, Lordship, will find on the page 34.
Yes.
Amendment Rule 18, Lordship. It was issued on 30th September 2021. This is most important. My entire case lies here, Lordship. In the Lordship, may I have your permission to read it, Lordship? In the principal rules in Rule 18, in 12 and 13 lines for the words, the person with disabilities, equal opportunities, protection of right and full Participation Act 1995 shall also be followed in direct recruitment in the following shall be substituted, namely. So earlier it was in 1995 Act, which has already been repealed. It was wrongly contained in the service rule. And that provision was challenged by the private respondent. Accordingly, this amendment is done. And the right of person with disabilities act shall be applicable in recruitment to the post of principal of provincialized higher secondary school, and also in case of all cadres, grades included grade 1 and grade 2 posts on the basis of total number of posts identified for the purpose of recruitment. Lordship, this slide is important. Number of posts shall be identified under the scheme of reservation. Next, Lordship, the reservation with person with benchmark disabilities shall be horizontal reservation. Horizontal reservation, and that the person selected against the quota for person with benchmark disabilities have to be placed in the appropriate category like SC, ST, OBC, unreserved, depending upon the category to which they belong in the roster meant for the reservation of ST, SC, OBC. So reservation is not clear, the horizontal reservation that anyone, everyone can participate. Now, Lordship, may peruse their affidavit. In the Lordship, the last
Which affidavit?
Affidavit in opposition they have filed in the page number 45. It is the recommendation made by the director to the government of Assam for approval of the private respondent.
1 minute.
Lordship, the reference is made. The endorsement.
Affidavit in opposition of respond number 3.
Yes, director.
Yes.
Then
page
45.
Yes.
Lordship, inviting reference to the subject cited above, I have the honor to state that the copy of Honorable High Court's order dated 3/3/2020 passed in WPC 955/2/2019 filed by Bharati Bhattacharya along with the representation dated 6/3/2020 submitted by Bharati Bhattacharya has already been communicated to the Gov by this office letter so and so for taking necessary action. Lordship, this point, Lordship, may be noted that this order recording the submission of the state respondent, the correction shall be made. Accordingly, the rule was amended. On that basis, she made a representation and that was forwarded for necessary action. Next line. After receiving the apostate government letter under reference number 2, a letter was issued to the inspector of school CDC Silchar to submit a detailed report regarding selection of regular principal in DNH school, Mudarbon Kachar. However, it is stated that the school selection committee of DNHS school Kachar submitted panel list in pursuance of the interview held in 10/1/2017. In the first interview where she has participated.
I've read all this.
And she was not placed in the merit list.
All the 3 persons in the merit list retired.
No, Lordship, they could not join because the pendency of the litigation.
Pendency of the litigation, after litigation was over, they had all retired. And the private respondent was in the fourth position.
Yes, fourth position.
She was also a disabled person.
She was disabled person.
And therefore, recommendation was made for appointing her as the principal.
As a principal under the scheme of reservation.
Yes. Then
my submission is that the rule contains that the reservation, the number of posts has to be identified first. Thereafter, advertisement shall be issued because it is a horizontal reservation. Anybody can participate. It is not reservation. The court is not directed her to be appointed under this scheme. Horizontal reservation, Lordship, it is clear. It is everybody can participate. SC, ST, general, who are the benchmark of disabilities. And first of all, the post has to be identified for that purpose. And without following that principle, that procedure which is laid down by the amended rule, they have directly appointed the private respondent under the scheme of reservation. This is my main case. So it is a gross violation of the Rule 18, amended Rule 18. Neither advertisement was issued, nor any interview was conducted, neither the post was identified, and most particularly, Lordship, she made a representation on the basis of that read petition, whereby disposed with observation recording the statement of the state respondent that the correction shall be made and the Rule 18 shall be amended. Accordingly, it was amended. Lordship will find the next page.
according to you, after the amendment, they should have issued an advertisement.
Advertisement. And post has to be identified. It is the clear indication of the amendment. Out of the total number of posts, certain posts are to be identified for the scheme of reservation for the person of benchmark with disabilities. Then the page number 246, Lordship. In the panel list, it is seen that Srimati Bharati Bhattacharya is in.
I've gone through. I've read.
Yes. And Lordship, another thing is that on the last occasion, when my interim prayer was rejected, I filed an appeal against the interim order, and they have submitted, the state respondent, that the private respondent is appointed only because he occupied fourth position. They remain silent about the scheme of reservation. Lordship will peruse this order. I have annexed my affidavit. May I peruse, Lordship? Yes. It is in my copy of the order. 214. It is in my affidavit dated 9/1/2023, affidavit in reply, in page number 66.
Affidavit in reply.
Yes, Lordship. Page number 66.
66.
Yes, it is relevant portion starts from 67.
Yes.
Lordship, this I'm reading out from the third paragraph. It is relevant. The case of the petitioner of the writ appellant was that he is already working as a principal of officiating basis in DN Higher Secondary School, and the private respondent number 5 has been appointed as principal on the quota reserved for the person with disability. Before doing that, as per the rule of Assam Secondary Education Provincialized Service Rule 2018, the post in district which has to be filled by disabled person must be identified. The post has not been identified as yet, says the petitioner writ appellant. Mr. R. Majumdar, Learned Standing Council, Education Secondary Department, on the other hand, would argue that selection and appointment has been done as per the rule in the Web Act in the year of 2016 by way of an advertisement which the present writ appellant as well as the private respondent number 5 had participated, whereas the name of the private respondent number 5 was placed at serial number 4 of the merit list. The first 3 candidates in order of merit list were asked to fill the post, but none of them joined the post of the principal. Meanwhile, the post could not be filled as there were several litigation filed in the matter. Now, once the litigation had come to end, the said exercise has started once again, and the respondent number 5, being the next best candidate in order of merit, has given the appointment. So there is a Lordship. My humble submission is that they stand before the division bench and they stand before your Lordship. It's quite different. They have submitted before the division bench. They know she has not been appointed under the scheme of reservation. At that point of time, I raised that issue because this appointment is illegal, without advertisement, without identifying the post. She has been appointed. Their position was that no, because she occupied the 4th position, and naturally from the waiting list, she has been appointed. My submission is that, Lordship, Supreme Court clearly says that if there is not a statutory provision in the Act to provide someone, to appoint someone from the waiting list, the authority cannot appoint anybody from the waiting list as a next available best candidate, because the merit list was prepared on the basis of certain facts and circumstances, considering certain facts. So if the system continues that if the 4th number, 5th number of candidate does not join, then 8th number of candidate will claim that yes, I am the waiting list, so why I should not be appointed, although she does not have a requisite qualification. The question is the requisite qualification. So, Lordship, I will place one decision of the Supreme Court regarding that aspect, that if there is no statutory provision in the rule or act, a person cannot be appointed from the waiting list. It is, Lordship, cited on 1991 AIR SCW. I have a copy, Lordship. Lordship, peruse the. I am extremely sorry, Lordship, that that was my copy. I had highlighted certain texts. and peruse the paragraph number 7.
Yes.
Paragraph number 7.
Yes.
In the present case, pursuant to the direction of the Honorable High Court of the High Court dated so and so, the appellant took steps for filling up 25 vacancies in post of operators from the advertisement number so and remaining 25 vacancies from advertisement number so and so.
Para number 7.
Para number 7, page number 4, Lordship.
It is not correct. It starts with, it is not correct, correct?
It is correct that I have highlighted.
No, there's no highlight.
There is no highlight.
Read it.
Lordship, para number 7, in the present case pursuant
No.
to the,
What is the case? What case is this?
oh, sorry. I have given wrong citation, Lordship. Extremely sorry. এটা নিয়ে
কোনটা না?
Yes.
Lordship, the present case pursuant to the direction of High Court dated so and so, the appellant took steps for filling up 25 vacancies in the post of operators from the advertisement so and the remaining 25 vacancies from the advertisement so and so. The results were notified on 29/4/94 on the notice board. The board recommended names of successful candidates under advertisement number so and the advertisement number so and so. Out of 22 candidates selected by the board for appointment under advertisement number so and so, 18 candidates did not turn up. At this stage, it is important to note that respondent number 1 to 7 had applied for appointment under advertisement number so and so dated so and they had qualified but were placed in the serial number 23 onwards in the descending order. As stated above, a panel of 22 candidates was prepared for appointment under advertisement number so and so. The respondent number 1 to 7 fell beyond cutoff number. We are not shown this part is important, Lordship. This respondent fell beyond the cutoff mark. We are not shown in statutory recruitment rules which require the appellant board to prepare a waiting list in addition to the panel. The argument advanced on behalf of the respondent number 1 to 7 was in effect that when 18 candidates failed to turn up, the appellant was bound to offer the post of the candidates in the waiting list. No such rule has been shown in this regard. In our view, the judgment of this court in the case of Shankarshan Das versus the Union of India clearly applies to the facts of this case. Further, there was no infirmity in the judgment of the court delivered on so and so. In our view, with respect, there was no need to recall the said judgment. So if there is no statutory provision to prepare a waiting list in addition to the merit list, the person cannot be appointed. from the waiting list. Yes. So Lordship, now I'll conclude my submission that in both the count, his appointment is liable to be set aside. First, they have violated the Rule 18, amended Rule 18. They did not publish any advertisement. They did not conduct an interview. In violation of the norms as contained in the Rule 18, they have selected the private respondent as a principal. And secondly, the submission which is made by my lord and friend in the division bench, it is also contradicted. So if this submission is also taken consideration, the Supreme Court says no, they are not entitled to appoint someone from the waiting list until or unless there is a statutory provision. But such provision is not there in the rule. This is my submission, Lords.
For the sake of argument, my lord, I will assume some of his submissions to be correct. I'm not admitting them to be correct, but I'll assume and start with them. She may like to have what he had shown at page, the merit list. Yes, at page 18. That's page 18. Now, when the first selection took place, the issue was that reservation for physically handicapped persons were not there. That is how the litigation started. Resultant was that we will give you the required litigation by amending the 2018 Act if necessary, but we'll give you the reservation. Now, we could not have, even if it is not there in the 2018 Act, being a central act, the Person with Disabilities Act is a central act. We had no option but to give the reservation. Let us have page 18 of the writ petition for a moment. My lord, here is a merit list. The first person to be shown is the private person.
Merit list.
This is a merit list, my lord. This is not a select list. This is a merit list. It is not a select list. It is a merit list. Persons, the names are there, and accordingly their merits are there. This is not in the order of merit, but it reflects the merit of each of the persons. Because Lordship will see at serial number 1, the total marks at the end, just at the second last column, Lordship will find 8.5. The next person, Lordship would find has secured 8 marks. Then Lordship would find the third person, writ petitioner, has secured 8 marks. So this, my lord, in effect is a merit list from where 3 candidates will be picked up, the one who have scored the highest.
I can't agree with this.
My lord.
In a merit list, absentees names will not be present.
Absentees. The person who was, it is from here that 3 candidates who secure the topmost marks will go.
They were given, so out of this list.
My lord, 3 persons had to be chosen.
This is an interview list.
Interview list. Let us, I correct myself. My lord, this is an interview list.
Out of that list.
Yes.
Select list was prepared. Select list was prepared. Page 17.
Page 17. These contain,
1, 2, and 3.
These contain the names of the persons who had scored the highest marks in the interview. Let me put it, if I put it that way, my lord. From page 18, persons who had secured the highest marks have been included at page 17.
Correct.
Had the reservation been applied as mandated by the central government, then the person with physical disability had to be included there. The reservation being there had to be included there. Not included was the ground of challenge by the present respondent, private respondent. Therefore, when this page 17 is wrong because it had to include the person with disabilities, meaning that this is the person with disability who is to be considered for a particular post.
But one thing, before you proceed,
My lord.
come to page 29. This is the judgment
Yes, madam.
of the division bench.
Yes,
Relevant part is page 33,
my lord.
para 5.
My lord.
Just read it.
The court has confronted R. Mazumdar, learned counsel appearing for the state with the fact that an advertisement has already been issued in context of Service Rule 2018. The said rules have some errors as admitted by the respondent state. What would be the justification of proceeding with the selection under the rules containing apparent errors? Mr. Mazumdar, learned counsel representing the respondent state has given a statement on the basis of instructions that the respondents would not proceed with the selection under advertisement dated 29/10/2019. We have not done that. We have not proceeded under any advertisement of 29/10/2019.
2019.
We have not proceeded with any advertisement.
So you have cancelled that advertisement?
Yes, it has not been proceeded with.
Then what is this advertisement? What is this select list all about? Which
This
advertisement?
is the advertisement where it was done before the challenge regarding the PWD Act came. We had already conducted an interview. We had conducted the interview. The school selection committee had given us a person with three persons on a merit list. It was at that point of time the challenge came that you have not made any reservation for the PWD. Repetition went ahead. It went the challenge to the.
No, I don't get it.
The advertisement pursuant to which this merit list had been prepared, Lordship will find given in the repetition at page 15. This is an advertisement of 2016. 2016 advertisement came first. I'll go date wise, chronologically. 16 we published an advertisement.
Yes.
Which consisted for the whole of the district. At page 16, Lordship will find there are at least 26 posts of principal being advertised for one district. He has selected out his own district while making the type copy, but otherwise it contains 26 schools. In fact, at that particular point of time, my lord, almost all the posts all over the state for the principal was vacant. Now, this is a district-wise advertisement, 26 schools. For this advertisement is what comes up at page 17. This Lordship will find is dated 12/1/2017, the merit list of 3 candidates after the interview was held. That point of time, the challenge came that when you are holding these interviews, you are not giving a reservation to the Person with Disabilities Act as per the Central Act.
This 2016 advertisement.
Yes, it did not contain the reservation for the PW, and therefore we suffer. Please incorporate it. Then in that repetition, I make a statement that very well. Now 2018 has come up. 2003 rules did not contain any provision for PWDs. 2018, we have introduced the new rules. New rules we are putting in the PWD part. So no one should have a grievance. We can go ahead with the advertisement. Honorable Court asked me, you have given the PWD Act of 1997. Sir, it has been amended it has been repealed and 2016 Act has come in.
95.
So Mr. Mazumdar, when you are naming 1995 Act in your 2018 Act, despite the fact that it is the 2016 PWD Act that you should have acted upon, your entire 2018 is wrong on the PWD part. So do you propose to proceed with advertisements? I said no. Unless we make the correction of bringing it into the 2016 Act, we will not proceed with any of the advertisements.
When was the 2016 Act? When did it come?
16. But when we made 2018, That process, the PWD Act, my lord, I will. 2016, it came before the 2018 A and 2018 Act and the 2019 Act. It came into effect in 2016 only.
Yes, of course, it came out in 2016.
Yes.
I want to have
The exact date, my lord, I am just. Yes, sir.
Anyway.
Well, that date I'll just apply, but it was prior to the date of the amendment to the 2018 Act, the Secondary Education Act. We did not notice it because the file was moving along with the 1995 Act. It started somewhere in 2013. When the NCT gave the new norms in 2010, 12 we gave the first amendment, then it started that no other amendments have come in, let us start. So 2013, when the file moved, it was with the 1995 Act. That is how it proceeded to be printed in the final. It was pointed out to us that it is a 16 Act, and therefore I made a submission that 2019 advertisement we will not go ahead because of the error apparent. 1995, it was a 3% reservation. 2016 Act, it is 4%. So I needed to increase 1%. We could have proceeded, but we said we honored the court and we said no, we will not proceed till that 2016 is brought in. Now, already a selection had taken place. All that was required to be done with regard to that selection was to give the reservation that was entitled to the candidates who were participating there, all the PWD candidates who were participating in that advertisement, under that advertisement, in that interview. If we gave the reservation to that, everything would be solved. There would be no further difficulties. Therefore, the private respondent was the only PWD candidate who had participated, claiming her right as a PWD candidate. Now, Lordship will find there are 26 schools in the district alone. 4% of 26 comes to 1.16. So one post had to be reserved for the persons with disabilities. If we take the whole of Assam, more posts. So without giving that one post to the PWD, we could not have proceeded further. We could have only given it to a person with a disability, to a post which was where she had participated. We cannot take her away to another school. We had to keep one post reserved. We have given that appointment because she was the only person with the PWD on that entire persons who had faced the interview board. So whatever be her merit in the entire list, being a PWD, one post had to go to her. How do we apply the horizontal reservation? She being a general category candidate will take up the unreserved post in the roster point. She being a woman, she will take up the woman post in the unreserved category. Where is the mistake? Here is a person, even if we go by the interview list at page 18, Lordship will find, while the private respondent who has now been appointed had secured 8.5 marks in total. At the top, she has secured 8.5. She is not the highest scorer, but she has secured 8.5. And the writ petitioner has secured just below her 8 marks. The second person was absent, third person, the writ petitioner, he has secured 8 marks. On merits before the interview board also, he would not stand a chance. His only claim as of today is, after the judgment of the Honorable Court to bring in that reservation, you should have gone for a fresh interview. Had I gone for a fresh interview, the position would be the post would be reserved for PWD. He does not claim to be a PWD. Where does he stand?
Hey, it is a future assessment.
Of what? Regarding a person with PWD. At least he is not one. It may be some other PWD who would come to the court and say that I must have been given a chance. I would have understood that. A person who is not claiming a reservation to be a person entitled to the reservation is before this court saying that there should be no reservation. Does he have a claim?
May I interrupt just one.
All in all, my lord, in my humble submission, admittedly, we had to keep a reservation. Not being denied that she was the only person with PWD to have participated in the interview process. Our hands being tied to consider her only for the post that she has participated in an interview.
No, one thing is this 2000 advertisement which you advertised, which you did not proceed with.
Yes.
Was it an advertisement repealing the earlier advertisement?
2019 advertisement.
Yes.
2019 advertisement has not been given, my lord. I will not make a statement that it repealed or did not repeal, but it
Because
included posts.
that earlier advertisement,
My lord.
and the 2008 advertisement were for the same post.
2019, no, not for the same schools.
Not for the same.
Not for the same schools. Not for the same schools.
Do you have a copy of the 2019
advertisement?
No, lordship.
19 advertisement was we have a copy of the 19
That process has been initiated, but it is not proceeded further.
No, that I understand.
Whether
You
it
have
had
a
repealed the
copy of the advertisement.
It is, I think, it is
19 advertisement.
it is enacted by or disposed of.
Lordship will have it.
Produce it in other
Lordship may like to have it day after tomorrow. The old records of this Bharti Bhattacharya case, my lord, if we bring it on, what was his exact challenge? Why we had to give up the 2019? Everything will be there. Of course, I had appeared in the matter. I remember in bits and bits, my lord. I do not remember the entire sequence, but I remember that question being put to me that when the 2018 Act is wrong, why do you proceed?
That part I am very clear.
I conceded.
2019, it has been
I had to
reported.
concede.
You have considered.
My lord, yes.
Before that, you said you are not proceeding.
I am not proceeding.
I was confused that it was a continuous of the.
That my lord, I'll have
But
it
then
on.
it is of 2016 advertisement.
Yes.
So when you made the 2019 advertisement.
Was it the same
did say
advertisement for the
anything
same
about
post?
2016 advertisement. This I want to be very.
My lord, lordship will give me. I could have taken it tomorrow, my lord, but tomorrow is a motion day. It will be pressure. Let it be there for tomorrow. Take it across.
Therefore, tomorrow is 23rd. Any other day, 23rd. I
Why?
have someone.
July. Oh, yeah, there's something. You're in difficult 23rd.
23rd more.
Oh, yeah, we'll do it.
We'll have it on 28 then.
28th. We'll do, yes. 28th, you're free?
28.
20.
And
Your good name, please.
Your good name.
Abject Mojumdar.
What, Mr. F. said Majumdar. Also heard Mr. R. Majumdar. Standing counsel,
Department of School Education.
Department of School Education, and Mr. And the council for the respond number. 5. This matter I can only 28.
Okay. Can it remain as part high class?
No, I'm not keeping anything part. Anyway, it will come up.
And Lordship, may I make one submission because can it be updated in the list? Can it be updated in the list and such indication may be given?
Mention in the morning with perhaps. Obliged. No, 16 to key.
My lord, 7, 8, and 9 are analogous matter, my lord. In item number 8, the affidavit in details have been exchanged between the parties. And the petitioner counsel is my learned friend, my lord. 8, item 8. So your lordship may be pleased to take item 8.
Oh, yes. Reply file person account. Copy that is into my data. I'll give it back to you.
Thank you. Yes, Mr. Modi, so something will be clear.
My lord, I am appearing in item number 8 and 9, audit petition 5 to 6 of 2023. So, my lord, the issue involved is a very simple one. In an advertisement for a direct recruitment to the post of teachers of lower primary and upper primary schools, the marks for experience of teachers who are working on the contract basis were not provided in the advertisement. Petitioners are contractual teachers working in upper primary and lower primary schools, and some of them working for more than 10 years or 10 years thereabout. So their grievance relates to this particular omission of recognition of their experience as teachers by way of weightage in the advertisement. Your lordship, kindly turn to page 60, which is the impugned advertisement. With a view to support, strengthen, and improve the quality of elementary education in the state of Assam in compliance with the Right to Education Act 2009, and in pursuance of government approval by the number so and so, and minutes of the meeting of empowered committee that held on so and so, communication by so and so. Online applications are hereby invited through the official website of DEE Assam, that is so and so, from the citizens of India as defined in Article 5 to 8 of the Constitution of India and qualified in Assam TET conducted by Elementary Education Department Assam for filling up of 7,242 vacancies of assistant teacher of LP schools of and 2,112 vacancies of assistant teacher, science teacher, Assamese language teacher, and Manipuri language teacher of UP schools under the Directorate of Elementary Education Assam. So a relevant part in my petition is at page 64, where selection process, page 64, the last item, 25, selection process is given. How to give the marks and determine the merits.
Selection process?
Yes. Clause 25, selection process. The selection of the candidate shall be strictly in order of merit, considering the reservation of EWS, OBC, MOBC, SC, STP, STH, PWD, etc., and marks will be allocated as follows. So the table A is for lower primary school and table B is for upper primary schools. Your lordship will find that there is no mention of any marks for experience as a teacher. However, the marks for 10 marks is given for NCCE who are holding C certificate, 5 marks for NCCE B certificate, and for certificate in recognized post representing Assam officially at national level, achievements in fine arts and cultural activities representing the state officially at national level. I mean, the marks have been given for other achievements other than the requisite qualification, educational qualification in these advertisements. Petitioners are qualified under the NCTE guidelines. I will come to that, but however, I want to take your lordship to page 58 and 59, which are the appointment letters of the petitioners. They would make clear that page 58. The basic qualifications the petitioners had and the manner in which they were appointed. The page 58 is the appointment order of petitioner number 1 in my writ petition. In pursuance of the provisions of the Right to Education Act 2009, And as per the advertisement number so and so, dated so and subject to satisfactory police verification report, the following candidate is hereby selected by Assam Sarva Shiksha Abhijan Mission, Assam, for engagement as assistant teacher in lower primary school and posted in so and so school, Kachar, district of Assam, on contractual basis. So the main point here is that the petitioners are qualified for appointment as teachers under the provision of the Right to Education Act of 2019. They have been found as such eligible and qualified way back in when they were first appointed in contractual basis. This petitioner number 1 has been appointed on 19/6/2014. So my main case rests on the ground that rules applicable for appointment and service of teachers, primary teachers, that is the Assam Secondary Education Provincialization Rules of 1977 provides for marks for appointment.
You could find it page 293, it starts.
Assam Elementary Education Provincialization Rules 1977.
293 of the new book.
Okay, my version is the old one.
You can have this.
Elementary education.
Yes, ma'am. Elementary education.
1977.
1977. Rules, 1977, 293.
The relevant rule is at page 294, my lord. The part 1, rule 3, method of recruitment. And your lordship have got clause B. It is at page 295. I'm reading out. The selection board on receipt of applications shall scrutinize and process the application forms, the mark sheets and other necessary testimonials of the candidates for interview by the interview committee. The selection board, on completion of interviews by the different interview committees, shall add marks secured by different candidates in the interview. The marks secured due to qualifications of the candidates over and above the minimum qualification, and the marks secured due to experience as a teacher, in the manner provided in Schedule 1, and prepare a list constituency-wise for each Assam Legislative Assembly constituency in descending order of the total marks secured by a candidate out of the total marks mentioned in Schedule 1. So this is the relevant part, my lord. Particularly, the marks secured due to experience as a teacher.
Let us see this Schedule 1.
Yes, Schedule 1, my lord, is at page 308. Schedule 1 has been amended, and this there is no provision for marks as marks for experience as a teacher. This has been omitted by amendment made in 2012. My submission is that
No, this is not the. Experience monthly, no.
this footnote in the book, my lord, 209 stated substituted Schedule 1 by notification number so and so dated the 12th October 2012 with effect from 25/10/2012. This is the substituted schedule. Earlier schedule has provided the marks for experience. In this regard, my lord, my submission is that the rule which is laid down in Rule 3 Clause B, I have read earlier, is the substantive rule. It entitles the teachers, the petitioners, to have their experience recognized in the recruitment process. This is an entitlement that this rule gives to the petitioners. And the schedule is a provision that lays down the procedure for giving effect to the substantive rule. While the procedure does not, the procedure is silent about this marks for experience, admittedly, after the amendment. So my submission is that if there is a right given by a law or substantive provision, it cannot be taken away because of the absence in the provision, in the procedural law. So in this regard, there are Supreme Court judgments Shravan Kumar. So this is Shravan Kumar Swarup and Sons, and 1994 6 SCC 623. 1994 6 SCC 623. I'm relying on this judgment, my lord. In respect to the provision regarding substantive law and procedural law. Para 15. The distinction between substantive law and procedural provisions has been indicated in Black's Law Dictionary as follows. As a general rule, laws which fix duties.
What is you're reading from para?
Para 13, my lord.
Okay.
The distinction between substantive law and procedural provisions has been indicated in Black's Law Dictionary as follows. As a general rule, laws which fix duties, establish rights and responsibilities among and for persons, natural or otherwise, are substantive laws in character, while those which merely prescribe the manner in which such rights and responsibilities may be exercised and enforced in a court are procedural laws. So this will suffice for our purposes, but the Supreme Court then went on examining other definitions, and in paragraph 15, my lord, an earlier decision was quoted, which says the division of law into two broad categories of substantive law and procedural law is well known, broadly stated, whereas substantive law defines and provides for rights, duties, and liabilities. It is the function of the procedural law to deal with the application of substantive law to particular cases. And it goes without saying that the law of evidence is a part of the law of procedure. So on this point, this will suffice. However, for the proposition that the absence in procedural law, absence of a provision in a procedural law does not affect the rights. I'm relying on Syed Muhammad Bakir Al Edrus decision, 1998 for SCC 343. 343. Paragraph 8, my lord. Paragraph 8, my lord. May I read out. A procedural law is always in aid of justice, not in contradiction or to defeat the very object which is sought to be achieved. A procedural law is always subservient to the substantive law. Nothing can be given by a procedural law what is not sought to be given by a substantive law, and nothing can be taken away by the procedural law what is given by the substantive law. So, in view of this, my submission is that, my lord, that the provision under Rule 3, Clause B, is the substantive law, and the schedule is the procedure. And there is omission in the procedure, admittedly, but that omission cannot be taken to have taken away our right to be recognized, our experience given in by the substantive law. And another aspect is that this clause B, the marks secured due to experience as a teacher, the definition of teacher. There is a new state law in relation to, in respect of posting and transfer of teachers. That act defines teachers, and I am relying on that definition. Yes, page 8, the act starts from page 8 in this book, my lord.
Which one?
The Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020.
Page 8.
Yes. Teacher is defined at page 10, clause P of section 2. Clause P. It's at page 10, my lord, the last clause of page 10. Teacher means all teachers or tutors of both elementary and secondary schools drawing salary or fixed pay or honorarium from the government exchequer or from Samagro Shiksha Abhijan, Assam, excluding heads of school. So this definition includes contractual teachers because they are drawing salaries, fixed pay. And most of the petitioners are appointed under working under the Sarva Shiksha Abhijan, Samagro Shiksha Abhijan, and some of them are in the state schools teachers. So this definition fits squarely. I am referring to this definition because there is another definition of teacher in the Central Act, Right to Education Act. Right to Education. This is not. Yes. Yes, page 2. It is this definition of teacher under the Right of Children to Free and Compulsory Education Act 2009. My lord.
There's no definition of teacher.
Yes, ma'am. Yes, teacher, it is not. So, in the definition clause of section 2, it doesn't appear that the teacher has been defined. So the only definition would be the definition given in the 2020 Act, in the State Act.
Proceed.
And that includes the contextual teachers.
What is the stage of this advertisement?
Selection has been carried out. Appointment has also been made, but in this case, the appointments are made subject to the outcome of this petition.
You applied for the.
Yes, all the petitioners have applied.
You participated in the interview?
My lord?
Did you participate in the recruitment process?
Yes, the recruitment process. Yes, we have participated in the recruitment process. And
when did you file this petition?
A few of the petitioners after advertisement. After we have made applications, and before selection has been made. Before selection has been made. So. Yes, because the selection has been made on the basis of the merits as per the education qualifications and qualification given in the selection procedure in the advertisement. So no oral interview and oral test was held. So on the basis of the merits found in the educational qualifications.
In terms of the advertisement?
Yes, in terms of the advertisement. Selection has been made, and the petitioners are.
The advertisement says no marks for interview.
No marks for experience. That is the only grievance in this petition, petition 5 to 6. And in item number 8, there is another relief, age relaxation in terms of the age relaxation for the contextual teachers, upper age for the contextual teachers. And the other two read petitions are for providing marks for experience. So there is a confusion, my lord, in regards to which provision governs the appointment process, recruitment process exactly. Because there is the Central Act of the Right of Children to Compulsory Education Act 2009. And under that act, there are rules and notifications has been issued. And then earlier, there were the state rules issued under Article 309 of the Constitution of India. So, in this regard, the respondents, particularly the Director of Elementary Education, in her affidavit, has taken a stand that this marks for experience is not provided in the rules and also not provided in the notification under Right to Education Act and in some official instructions. So on this point, my humble submission is that the Central Act of Right to Education is an act that provides for how to give quality education in terms of right to education as a fundamental rights. To implement the fundamental right to education. The statement of object and reasons will be relevant to interpreting and understanding the provisions of the Act and rules made thereunder, my lord. The crucial role of universal elementary education for strengthening the social fabric of democracy through provision of equal opportunities to all has been adopted since inception of our republic. The directive principles of state policy enumerated in our constitution lays down that the state shall provide free and compulsory education to all children up to the age of 14 years. Over the years, there has been significant spatial and numerical expansion of elementary schools in the country, yet the goal of universal elementary education continues to elude us. The number of children, particularly children from disadvantaged groups and weaker sections who drop out of school before completing elementary education remains very large. Moreover, the quality of earning achievement is not always entirely satisfactory, even in the case of children who complete elementary education. And this is the statement of object and reasons, my lord. Section 23 is relevant. Section 23 of the Act provides for qualifications for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary, by notification relax minimum qualifications required for appointment as a teacher for such period, not exceeding 5 years, as may be specified in that notification, provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. So these provisions that enables notification to be issued prescribing minimum qualification is itself speaks of minimum qualification. In fact, the entire act provides for minimum standards to maintain pupil teachers ratio, minimum standard of the teachers, their qualification eligibility.
Majumdar, this rules of 1977 was amended.
Yes.
by the 2012 rules.
My lord, prior to that in 1997, prior to that in 2005. 2012 came in much later. 1977 was
But
first
which one is
amendment.
holding the field now? 2012.
The amendments which have been made in 2012, they hold the field. But I'll show how those words of the marks for experience have crept in. I'll show that. I'll explain that part to show that experience, giving marks for experience or not, is something in the realm of the administrative authority, which we did not want to exercise in the absence of powers in the rules or in the absence of what was there in the rules. If he finishes,
I'll just show you. So this notification issued by the NCTE, which is annexed in the writ petition, has been issued under the provision of this section 23 of the Right to Education Act. So NCTE notification in my writ petition is at page 102. In exercise of the powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education 2009, and in pursuance of notification number so and so issued by the Department of School Education and Literacy, Ministry of Human Resource Development, Government of India, the National Council for Teacher Education hereby lays down the following minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in clause N of section 2 of the Right of Children to Free and Compulsory Education Act 2009 with effect from the date of this notification. So these are the minimum qualifications, and the petitioners are found to have been qualified under these provisions. Therefore, they were appointed as per the appointment order. And also, since they are qualified under this notification, their application under this impugned advertisement were accepted. Otherwise, their application wouldn't have been accepted. So, what we are seeking, is not relaxation in the minimum qualifications. We are seeking recognition of our experience as teacher over and above the minimum qualifications. Like other achievements were recognized as NCC cadet and achievements in sports and or other achievements. So we are seeking that our experience as teachers be recognized. And in other departments, particularly the secondary schools, in secondary schools, graduate teachers and postgraduate teachers, in the rules, there are provision for giving experience as teacher in the recruitment process. Graduate teachers and postgraduate teachers, my lord. In the petition, I have annexed some advertisement. At page 75, this is an advertisement for graduate teachers. The marks for experience is given at page 76, my lord. Minimum qualification, minimum educational and professional qualification for direct recruitment in the post of graduate teachers. Clause 6, my lord, towards the bottom. 50 marks at the rate of 25 marks for 1 year of teaching experience as contractual teacher, and another 25 marks for 2 years, subject to consideration for a minimum period of 2 years. And then another advertisement. at
This
page-
is secondary school, isn't it?
Secondary school, my lord. Secondary
We're
school,
concerned with primary.
not primary. So my point here is this, that other teachers, teachers of secondary schools, graduate teachers, postgraduate teachers, they are recognized, their experience is recognized in the process, in the selection process. And our and other departments also, my lord. Health department, there is also an advertisement I have annexed, health departments where marks for experience has been given. My submission is that, my lord, this is a discrimination. And it is hit by Article 14 and Article 16 of the Constitution of India, my lord, because there is no differentia, intelligible differentia for making 2 class, 1 class for primary, 1 class of primary school teachers and another class of secondary school teachers for the purpose of recognizing experience, giving experience. There is both of them are teachers. Both of them, both of the groups gain experience, valuable experience while they work as teachers. And there is no reason why 1 class of teachers' experience should be recognized and the other class of teachers' experience should not be recognized. Both of them work in the same profession, my lord. So, in brief, my submission is that this discrimination is hit by Article 14 and 16 of the Constitution of India, my lord. And another ground is since it is provided in the rules, my lord, and the experience has been recognized from earlier, the petitioners have a legitimate expectation of their experience gained as a contextual teachers to be recognized in any recruitment process, because it is in the rules. And in case of other teachers, this has been recognized, and in other departments also, this has been recognized. So petitioners have a legitimate expectation of their experience being recognized, marks for experience to be given to them in the recruitment process. My lord. So for
Anything more?
yes, my lord. On the legitimate expectation, another jails, Navajit.
Yes.
So GNCT of Delhi and others, this is a decision by division bench of the Delhi High Court, my lord, where the term legitimate expectations is made clear. This I'm referring to paragraph 21 onwards, my lord. What is the doctrine of legitimate expectation? After a survey of leading decisions on the point, the legal position with respect to legitimate expectation can be summarized as under 1. Mere reasonable or legitimate expectation of a citizen may not by itself be a distinct enforceable right, but failure to consider and give due weightage to it may render the decision arbitrary. 2. Legitimate expectation may arise if there is an express promise given by a public authority or because of acceptance of a regular practice, a claimant can reasonably expect it to continue, and such expectation may be reasonable. 3. For a legitimate expectation to arise, the decision of administrative authority must affect the person by depriving him of some benefit or advantage which he had in the past been permitted by the decision maker to enjoy and which he can legitimately expect to be permitted to continue until some rational grounds for withdrawing it have been communicated to him. If the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make a representation in the matter. The doctrine of legitimate expectation permits the court to find out if the change in policy, which is the cause for defeating the legitimate expectation, is irrational or perverse, or one which no reasonable person could have made. So on the basis of this summarization of the doctrine of legitimate expectation, we are taking the ground of legitimate expectation because the when some of us were appointed, some of the petitioners, it was also in the schedule. Some of the petitioners have been appointed before 2012 and in the schedule. And when we have been first appointed, the marks for experience, provision for marks for experience is in the rules. And then the practice is everywhere still in the other departments, in the health department, in the police department, and in the secondary education department, as I have shown. So and there is no reason for why our experience should be denied to be recognized. So on this ground. And the other decision, Navajyoti Cooperation Group Housing Society and others, this is a Supreme Court decision, my lord. Paragraph 15 and 16 makes the point on legitimate expectation. Right? It also appears to us that in any event, the new policy decision as contained in the impugned memorandum of January 20, 1990 should not have been implemented without making such change in the existing criterion for allotment known to group housing societies if necessary by way of a public notice so that they might make proper representation to the concerned authorities for consideration of their viewpoints. Even assuming that in the absence of any explanation of the expression first come first served in rule 6.4 of Najul rules, there was no statutory requirement to make allotment with reference to date of registration. It has been rightly held as a matter of fact by the High Court that prior to the new guideline contained in the memo of January 20, 1990, the principle for allotment had always been on the basis of date of registration and not the date of approval of the list of members In the brochure issued in 1982 by the DDA, even after Gazette notification of Najul rules on September 26, 1981, the policy of allotment on the basis of seniority in registration was clearly indicated. In the aforesaid facts, the group housing societies were entitled to legitimate expectation of following consistent past practice in the matter of allotment, even though they may not have any legal right in private law to receive such treatment. The existence of legitimate expectation may have a number of different consequences, and one of such consequences is that the authority ought not to act to defeat the legitimate expectation without some overriding reason of public policy to justify its doing so. In a case of legitimate expectation, if the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make representations in the matter. In this connection, reference may be made to the discussions on legitimate expectation at page 151 of volume so and so. It has been held in the said decision that an aggrieved person was entitled to judicial review if he could show that a decision of the public authority affected him of some benefit or advantage which in the past he had been permitted to enjoy and which he legitimately expected to be permitted to continue to enjoy either until he was given reasons for withdrawal and the opportunity to comment on such reasons. And this marks for experience has also been provided in Umadevi case, my lord. Umadevi. And Delhi University. My lord, I don't have a copy of the Umadevi decision with me, but I have highlighted the relevant part where for casual workers, it was directed that their experience should be given due weightage. And the other decision, my lord, the University of Delhi versus Delhi University Contract Employees Union and others. Paragraph 5. Yes, I have given.
Oh, yes, yes.
Yes. Paragraph 5. In this case, my lord, the Delhi University did not provide marks for experience for its contractual employees in a direct recruitment process. The aggrieved employees union went to the Delhi High Court, and Delhi High Court single bench allowed the petition, but they when in appeal the division bench reversed the decision of the honorable single judge. But then university went to the Supreme Court, my lord. In the Supreme Court, during the pendency of the petition, paragraph 5, my lord, the university took a decision. The learned counsel for the petitioner seeks to argue that respondent university is appointing person on contractual basis pursuant to the earlier advertisement dated 35/2013, and which should not be done in view of the ratio of the judgment of the Supreme Court in case of Umadevi. This argument is misconceived for various reasons. Next clause F is relevant. In the recruitment process pursuant to the advertisement dated 6/11, 2013, the junior assistants employed on contractual basis also participated. All contractual appointees were granted age relaxation. However, only 120 regular appointments could be made by the university, out of which 10 were contractual appointees and members of the union. Then paragraph 6, my lord. In the affidavit dated paragraph 6, in the affidavit dated 9/3/2021 filed on behalf of the university, it is submitted that a decision has been taken that in order to facilitate the contractual employees to participate in the recruitment process, age relaxation as well as certain advantage for the service rendered as contract employees will be given by the universities. Paragraph 6 and 7 of the said affidavit read as under. 6, in view of the order of this court to enable the contractual employees to participate in the recruitment process, a comprehensive age relaxation with respect to the upper age limit has been given to the contract employees working at the university in the present recruitment process. 7, in addition to the above, a maximum of up to 10 extra marks, depending on the number of years of service of the contract employee, would be given to them while finalizing the merit. And the decision of the Honorable Supreme Court is at paragraph 18, my lord. Paragraph 18. We therefore direct that all the concerned contract employees engaged by the university be offered benefits as detailed in paragraph 6 and 7 of the affidavit dated 9/3/2021 with the
Before
following.
concession was made.
My lord.
Concession was made by the respondent.
By the respondents. So I am referring to this because the respondents in their affidavit taken a stand that giving marks for experience to the petitioners and similarly situated teachers would violate Article 40. So when the in Umadevi cases, the Supreme Court itself directed for giving weightage, due weightage. And in this case also, in the Delhi University case, the Supreme Court approved these steps, this provision. So there is no question of giving marks would violate the provision of Article 14 and 16, my lord. On the contrary, this we have qualified. We have qualified in the qualifying exams way back 12, 13, 15 years back, and now the new batch who are now passing out, coming up. They are the new, fresh, passed out people. So we have got little less marks.
The earlier system.
Yes, because of the earlier system. And now they are getting more marks. So this has put us in a disadvantaged position. We are just, therefore, our experience as teachers in every profession, experience is recognized, my lord. In our this advocacy profession as well, in lawyering profession, in every profession, in medical profession, and also in teaching profession, the experience is recognized and weightage is given everywhere. So to summarize my submission for the time being, if after my learned friend's submission, if a reply is required, I will make a brief reply. But now to summarize it, we are claiming that our experience as teachers be recognized in the recruitment process, due weightage be given, because it has been recognized in the substantive rules, in the rules governing appointment and service of teachers of elementary education, provincialization of services rules 1977. And even though the schedule that provides procedure has been amended and this provision has been omitted, but in the substantive provision, it is still there. And so, therefore, substantive, where there is a substantial entitlement by a substantive provision, it cannot be taken away because of the lack of procedure or provision in the procedural law. So, and this Right to Education Act of 2009 and rules framed there under notification issued under the provision of the Act, my lord, these provides for minimum standards like student pupil ratio and also minimum qualifications. The petitioners are eligible under these standards provided by the NCTE. They have been found as such when they were first employed, and then also when they have filed their application under the impugned advertisement, my lord. What the petitioners are seeking is recognition of their experience over and above the minimum qualifications, my lord. We are not seeking relaxation of the minimum qualifications because we are already qualified, my lord. So, and the other ground is that non-recognition of marks for experience is violative of provision of Article 14 and 16, my lord, because the other teachers, graduate teachers, postgraduate teachers are being given this recognition. Only the primary teachers are deprived of this weightage, and without that there is no differential in intelligible differential between the two classes, two groups. So it is hit by the provision of Article 14. And then the legitimate expectations. My lord.
Yes.
My lord, two things have hit me today. One is that this in the rules of 1977 at page 29, there is a reference to the marks secured due to qualification by the candidates over and above the minimum qualification, and marks secured due to experience as a teacher. That is what, my lord, the petitioner is trying to establish, that this is a part of a substantive law, and that the marks secured due to experience as a teacher has to be taken in because it creates a substantive right in favor of the petitioner. For that, I would require, my lord, a little time. I'll take, if lordship takes it up at 2. I'll have to go through some judgment to just see whether this can be called a substantive law or not, in view of the fact that it also refers to the selection board on completion of interview shall add marks secured by the different candidates in the interview. In fact, we have not even given marks for interview in the schedule. So if the petitioners are not insisting upon the marks of an interview or holding of an interview, can he pick up one part of the act, one part of the substantive rule, as he says, to say that the marks for experience has to be given, but the marks for interview or holding of an interview can be totally ignored. Marks in an interview would be marks which one cannot determine. But marks for experience would be something that he would have some hold upon to at least assume that this is what I am supposed to get. So what is uncertain, he gives up. What is which is he allowed to do that when trying to interpret a provision of law? Is one aspect, my lord, I'll have to address to. Second aspect, my lord, the 2005 amendment I have to place before lordship, my lord. That is perhaps not in the new book, my lord. The old book, I have to make a copy of it and I have to place it before lordship. 1997, the amendment which had come in, and how this remained while everything else changed. That I'll have to place before lordship, so the lordship would like to appreciate as to why it would be upon the department to evaluate to see whether experience is somewhere where I want to give them marks or not. Is it something that he can claim as a matter of right? If it is not given, does it violate any of any provision of Article 14 or 16?
This 3B has been amended.
3B, madam, as it is printed in the new book, is as it is, madam. It is a 3.
This is in force.
3B is in force. Now, 3B in force meaning that we also have to hold an interview. It provides for an interview. Petitioner does not require that. He does not insist on that.
Yeah, my lord, but one violation that cannot justify another violation.
No, I'm not on one violation of this one. I'm on whether insistence on one, leaving out another can be justified. So that is what I'd like to address lordships on. Could it be, my lord, either at 2 today or on some other lordship's convenience, my lord. I'll be, just need some time to go through these rules to find out the sequence. Has there, sir?
Yeah, Mr. Olaskar.
Yes, sir.
Has there been a Thursday?
But Mr. Olaskar and the counsel for the petition and WC 526 of 2022. And WC 2313 of. Also heard Mr. MH. Raj Korea. Yes. Then the counsel for petitioner in WC 780 of 2022. List the matter again on. We'll have it on Thursday then.
Yes, madam. Yes, I'll be better people.
23rd. That's what.
Further hearing.
Yes, further hearing. I may be allowed to make some submission on the violation of Article 14 and 16.
You can do it after I finish. Obligation.
আমরা যেমন 60%.
None appears for the petition. Ms. D. Musharraf and its standing counsel.
Secondary Education Department.
Secretary Education. Appears for the secretary. Mr. Matter again.
Obligation.
My lord, in this case, I am respondent principal, my lord. My lord, matter may be disposed of today itself because of that, my lord, due to suffering the all students, my lord, from my lord 2016, my lord. My lord, this post was hold, my lord, all students are suffering, my lord. So I think I may be, matter may be disposed of today itself by principal college authority pressurizing me, my lord, to dispose of a matter, my lord. Already advertisement was
Let's
issued,
see
my
what the
lord.
other side says.
Yes, madam. What are this matter addressed to the approval by the DSC?
Well, at 2, my lord, at 2, my lord, at 2, my lord. Otherwise, my lord, all students communities are suffering, my lord, due to non-appointment of the post, my lord. At 2, my lord. At 2, March.
Conducting counsel in this matter is on legs. What should the pass over the matter for timing?
Lordship, otherwise also there are some instruction awaited lordship in this matter from the department. Lordship may post the matter next week, lordship. In the meantime, we'll have instruction. The instruction is awaited.
You, Mr.
R. Chauhan.
Huh?
Chauhan.
Mr. R. Chauhan, runner counsel for the petition. On the first made by Jane Sharma, legislative counsel, elementary.
Elementary lordship.
Elementary.
Petition is
List the matter.
No, sound.
You want it after 2 weeks?
Lordship, lordship.
May it please your lordship. Lordship, in this case, my senior as the senior advocate, he will be arguing. But if he is indisposed today, can it be taken up after 2 weeks, Lordship?
On the request made on behalf of the senior counsel.
Yes.
For the petitioner, list the matter of 2 weeks.
Deeply honored.
Was it contempt 15, Lordship? As far as section is complied.
Where is RTE?
He sees here. Then at 2 Lordship, he will appear, then the rest is complied. There. We are 2 Lordships, he will then come.
Where is the compliance order?
Not with me, they will inform me that there is complied. At 2 then in the commission.
Annual annual increment that has not been released.
Sometime maybe allowed instruction not received.
More particularly, petition number 2 and 3. One has been already processed, but 2 and 3.
Have you filed your impeachment application? Thus.
Lordship?
Have you filed your impeachment application?
As they have already processed, mean they are minor, and already Vijay Sudhiri is there.
Have you filed your impeachment application?
Yes, another new Mamata House I have to file implete mallet. Mamata House. Director of Secondary Education. New.
Have you filed?
No, not filed.
Are you filing or not?
Yes, my lord. In this time, I will correct it tomorrow. Day after tomorrow I can file.
Does as a counsel for the petitioner is allowed 1 week time to file an appropriate application for impeachment of cases. This after 1 week.
Yes. In this way, the one instruction has placed here, my lord. DO Nogao reported by this letter under reference number 3 that the proposal of arrear salary for an amount of rupees 7,20,488 has been forwarded to the inspector of school NDC Nogao. By this letter under reference number 4. And as desired by the government, it was taking further necessary steps to this.
Yes.
Regard compliance, for compliance. So my lord, this letter is a director.
Compliance one. So some time will be allowed for the final compliance.
For filing compliance report.
Yes, my lord. So 2 weeks.
MS.
Yes.
The counsel for the condemned number 2.
Condemned number.
He is appearing on behalf of
B.
Kosik, respondent 2, my lord.
Mr. U. Sharma, the counsel appearing on behalf of B. Kosik. The counsel for the respondent number 2. Is allowed. How much time you require for filing compliance?
2 weeks, my lord.
Allowed 2 weeks time for filing compliance report. Please stop. 2 weeks.
My lord, in this regards of the one instruction received for compliance, compliance of order, here I have placed.
Well, I have not gone through that, Lordship. May I pay Lordship a copy of that too? Lordship, may
I will find it.
at 2 p.m. Lordship. I will go in the meantime to the all of us.
Internal, shall we resume at 2? Maybe 10 minutes.
Yes, no problem, no.
As per Rule 14 of Assam Secondary Education Provincialized School Services Rule 2018, a teacher of high school should be a graduate in a particular stream or subject with BT, BA degree from recognized university. They have no such degree, my lord.
Their stand has
So,
already
my
been
lord,
taken
if
in
they
the
want
order
to
dated
challenge,
25.
they may file a writ petition, fresh writ petition.
You have to challenge this in the.
Yes,
That is, we have to challenge it.
Yes.
M. Khan, Learning Council. What Mr. M. Khan, Learning Council. Mr. U. Sharma, Learning Council. Approving 48.
No contempt.
Which respondent?
1 and 2, man.
1 and 2.
3.
Has produced an order. dated
3 as an 1, 2 and 3, man.
1 to 20. All the respondents has produced an order dated 20 February 2023, issued by the Secretary to the Governor of Assam, Department of School Education. On perusal of the same, this court is of the considered opinion that substantial compliance has been made. Accordingly, contempt petition is closed. However, with liberty to the petitioner to challenge the order dated 20 February 2022 before the adequate forum, if so advised.
My lord.
Order dated 20 February 2023 is placed on the floor.
May it please the Lord. Lord, the matter relates to appointment to the post of assistant professor of the provincialized college. Selection was made. I was put in a panel of 3 persons. Selected candidates were prepared. I was in the 3rd position. 1 and 2, they didn't join. 1 and 2, he showed his disinterest. He intimated that he is not willing. So also ultimately number 2. So 3rd only I remain. I will go to the facts more detail. I remain. So ultimately my case was recommended. Resolution was taken by the governing body of the college and sent it for issuing the appointment order by the director. But director has kept it pending and he has not issued the order since 2018. Now this is 23. Therefore, the petitioner has to approach this honorable court that the director cannot on his turn illegally hold it back or deny appointment when the selection was legally made and recommendation was just received. And therefore, he is bound under the rules to issue appointment. Now, they have filed, the government has filed the affidavit of opposition. They have taken the point that, well, since there were 3 candidates, selected candidates in the panel, that itself was not fair, not proper, not legal. There ought to have been only 1 selection. At any rate, when 3 candidates were there, first one was recommended, that candidate didn't join. Second also didn't join, so it got exhausted. You could not have recommended the name of the third candidate. Therefore, this recommendation we are not bound to act. That is what the one leg of argument. Second, they say that this is more so because under the act, this is called FRBM. Yes, acronym. Assam Fiscal Management, Fiscal Responsibility and Budget Management Act, they call it. Assam Fiscal Responsibility and Budget Management Act 2005. There it also prohibits more than one selection, only one panel of one candidate. Therefore, this panel is bad and therefore we are not obliged to issue appointment order. This is basically the case, their case, they have raised these 2 points. Now, since it is ready, Lordship will hear it on merit and it can be decided. Then we come to page 27. First, Lordship will kindly come to page 27. This type copy Lordship will find at page 24. Extra 1A. This is the letter dated 27th of June 2017 by the Director of Higher Education to the Principal Sunari College, the concerned college, where I appeared for interview and vacancies there. So they say, permission for advertisement of the post of assistant professor. Permission is accorded to the following post to be advertised in 2 local leading newspapers with wide circulation for direct recruitment. So number 1 is assistant professor political science, reserved for SC. Roster point 22, approval of administrative department was given. Other post was in July, we are not concerned with. And then condition was given, age 43, this and that, those were of no dispute. Qualification, essential education qualification has been mentioned there. There is also no dispute. These are all, I fulfill all, everything here. And then Lordship may kindly come to the crucial portion I want to point out at page 26. And this type copy at page 26, my lord, second para. This your Lordship will find in the next page 27 in the original letter photocopy. We may read from the original letter page 27, my lord. Same copy, original one. Should I read it, my lord?
Yes.
Page 27, last but one para. In the event of first candidate joining elsewhere or not offering to join, the appointing authority may go in for preparing select list up to candidate number 3 in the comparative statement and not beyond, subject to approval of governing body. This is for avoiding successive re-advertisement for the same post. So it says, my lord, it indicates that in the event of first candidate joining elsewhere or not offering to join, the appointing authority may go in for preparing select list up to candidate number 3 in the comparative statement and not beyond, subject to approval of governing body. And reason has been given. This is for avoiding successive re-advertisement for the same post. So it clearly says that you go for advertisement, take candidates, select candidates, and you can go up to the panel. A panel can be prepared up to 3 candidates. Third, 3 candidates can be selected, so that in case of the other 1, 2, they choose not to go for. In that case, you need not have to go for advertisement. So thereupon, the advertisement was issued at Annexure 1 Annexure 1, my lord, lordship will find, page 23. The for publication, it was accordingly issued. Sunari College, Principal Sunari College. It was in Tribune 15/7/2017 in Assam Tribune. This was published. Accordingly, I applied. There was a selection held. Lordship will kindly come to page 28, Annexure 2. This is the consolidated mark statement selection for the post of assistant professor, Department of Political Science. The selection committee, this is the consolidated mark statement. Here lordship will find 1, 2, 3, 4, 5, 6 candidates altogether appeared. And their marks have been mentioned here in these columns. And in remark column, lordship will find number 1 has been put against the third candidate, Nilaksi Das. Nilaksi was the first recommended candidate. Second was Debo Narayan Hazurika. And third is my Swarna Jyoti Das. I was recommended at the third place. So these 3 candidates, 1, 2, 3. Now, photocopy is at page 29, my lord. That is it contains the signatures of all the stakeholders there who were in selection. Therefore, ultimately, this first recommended candidate, she submitted this application to the principal at page 30. That she is not willing to join. Therefore, she says, what did she say? I sincerely request you not to consider me for the last but one para. Above mentioned post. I do not have any objection regarding appointment of assistant professor of political science in your college according to the established rules. So she gave this letter to the principal saying that she is not interested. She doesn't like to come for this job. And therefore, she was informed by the principal by Annexure 4, page 31, that we have received this and acknowledged it. And then, my lord, the second candidate name was recommended. At page 33, lordship will find. When the second candidate was recommended to the director, director said by this letter to the principal regarding approval of assistant professor, Department of Political Science, your letter number so and so, dated 21/10/2017, with reference to the subject cited above, I would like to state that the selected candidate for the post of assistant professor in the Department of Political Science, Sri Debo Narayan Hazarika, has been working as postgraduate teacher at Naharkatia Higher Secondary School. He has not submitted NOC. Hence, the proposal submitted by you has been rejected. So, that proposal was rejected because this Hazarika, Debo Narayan Hazarika, did not submit his no objection from his employer. Then, meanwhile, what happened? The candidate, that Debo Narayan Hazarika, approached this honorable court. He approached this honorable court. Lordship will find the order at page 39, Annexure 8. He filed this case. And here, Lordship may see at page 40, paragraph 4. In the selection for the post of assistant professor in the political science in the Sunari College, Saraidu, the petitioner along with the respondent number 6 have participated in the selection process. The petitioner, having secured 66.08, was placed at serial number 2 whereas the respondent number 6, having secured 63.54, was placed as serial number 3. Later on, 9/10/27, the first candidate on merit, Srimati Nilakshi Das, has refused the offer of appointment, and consequently the petitioner became the first selected candidate on merit. However, the respondent authorities are contemplating to appoint the respondent number 6. As against such grievance, this writ petition had been filed. So that was an assumption he filed, but his case was recommended by the college authority to the government. Government in fact refused because of non-submission of NOC. Here, of course, the court at the last paragraph, Lordship will see, 6, in view of the above, on being prima facie satisfied and also considering the balance of convenience and the irreparable loss that the petitioner may suffer, it is provided that the respondent number 6 nor any other candidate shall be appointed to the post of Assistant Professor of Political Science in the Sunari College until further orders. That was interim protection was given. And thereafter, he was meanwhile employed elsewhere, he was not interested. And therefore, he ultimately came before this court, page 42. It says that Sri Gogoi, Learned Counsel for the petitioner, submits that due to certain new developments which have taken place after filing of the writ petition, he would not like to pursue the present writ petition. Accordingly, same stands closed as not pressed. Consequently, the interim order passed earlier stands vacated. It is made clear that on closure of the writ petition and the vacation of the interim order, the college authorities may go ahead in accordance with law. It was vacated. Meanwhile, he got absorbed elsewhere. Therefore, he decided not to go for, and he abandoned this petition. So, post remained vacant. He didn't turn up. And then the authority recommended my case. Annexer 6, page 35, Lordship will find. After this, this was 24/1/2018. It was to the director. It was earlier also written that 2017. Now again, with reference to the subject cited above, I have submitted here with the resolution of the governing body Sunari College held on 8/1/2018 for appointment of assistant professor against retirement of Sri Ganesh Borua in the Department of Political Science for your approval. It is to be mentioned that in the panel of selected candidates, Ms. Nilakshi Das, the first candidate, refused to join, and the copy of her refusal letter is attached. Further, the proposal of second candidate, Sri Devonarayan Hazarika, was rejected by DHE so-and-so, dated 31/12/2017. In view of this, the governing body resolved to send the name of the third candidate, Dr. Swarnajyoti Das, for approval for the post of Assistant Professor, Department of Political Science, as per letter number so-and-so, dated 27/6/2017. That original letter of the director has been referred to. This proposal was sent. It was lying there. Governing body's resolution, extract Lordship will find at page 37. This was the resolution recommending my name. Third candidate was recommended for appointment. Therefore, now the desk was clear for the authorities to appoint me. They have not done it. Again, the matter was taken up by the authority because the matter is pending. So 23/5/2022, page 47, annexer 12. The college authority again took up the matter and requested the director. It says that inviting reference to the subject cited above, I have the honor to submit herewith the resolution of the governing body Sunari College held on 18/1/2008. That was reiterated regarding appointment of assistant professor against retirement of Ganesh Borua in the Department of Political Science for your kind approval. It is also noted that earlier the first selected candidate refused to join and the second selected candidate was rejected by DHE Assam for non-submission of NOC. In view of this, the governing body resolved to send the name of the third candidate approved, but the second candidate filing a writ petition, and Honorable Guwahati High Court stopped in the approval of the appointment until further order. Now, the Honorable Guwahati High Court vacated the earlier interim order, and the DHA Assam also directed to submit the proposal for the same. And the college authority also like to retain the earlier GB resolution as it is in favor of the third candidate, Dr. Swarna Jyoti Das. That's sir. I would like to request you to approve the appointment of Dr. Swarna Jyoti Das against the post of assistant professor in the Department of Political Science, Sonari College. So this was on 23rd May 2022. And since then, nothing has happened. This is why I had to approach this one before. Now at this stage, Lordship will kindly see the rule. Law, what is the rule prevailing in this particular field? Can you take up the education manual? Yes. My lord, Assam College Employees Provincialization Act 2005. This book, page 490. This is basically the act to facilitate the provincialization of the colleges. Lordship will kindly find at page 490, preamble, whereas it is expedient to provincialize the services of employees of the non-government colleges in receipt of the deficit grants in aid from the government of Assam. It is hereby enacted. Therefore, for that purpose, for provincialization, this act was enacted. Lordship will kindly come to section 6, page 493. No, more just the whole question. Here, it says selection and appointment of employees. Appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective college in accordance with the rules and procedure of the government in force. Courts will kindly note this. Specific provision made that appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of the Higher Education on the basis of selection and recommendation of the governing body of the respective colleges in accordance with the rules and procedure of the government in force, provided that some of the powers of the appointing authority may, however, be delegated to the governing body of the colleges as may be provided in the rules. This is not applicable to us. So firstly, it says that director shall make appointment, but at the recommendation, selection and recommendation of the governing body of the college in accordance with the rules and procedure. To my humble understanding, this law provides that if the selection is made as per the rules, following the rules and procedure, the director has no other power save and except issuing the appointment order. Therefore, kindly see the rules made here under, whether it says something else in this regard. At page 497, Lordship will come. This is the rule at 496, Assam College Employees Provincialization Rules 2010. Page 497, Rule 5, Method of Recruitment. Recruitment shall be made in the manner prescribed hereinafter. We'll go to 2, my lord. Sub-rule 2. For the post of lecturer, because we are lecturer, librarian appointment shall be made by the direct recruitment by direct recruitment with prescribed qualifications through open advertisement in 2 leading dailies, at least in 2 consecutive issues. In respect of grade 3 and grade 4 posts, the list of candidates shall be collected from the local employment exchange advertisement in newspaper. So it says about advertisement. Now kindly come to Rule 7, next page, 498, Sub Rule 7. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment.
Who is this? Who is this? 7.
7, Sub Rule 7.
Sub rule 7.
Yes. Rule 5, Sub Rule 7. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. Very categorical, definite. The rule makes it very categorical that there is no option left to the director, 7, except issuance of the appointment order. Once the selection is made by the governing body and the governing body recommends thereafter the name of the candidate. Lordship may also go to Rule 7. It says about direct recruitment. We are concerned with B, 7, Sub Rule B. We may also read Sub Rule A, my lord. All appointment, either by direct recruitment or by promotion, shall be made by the director on the basis of recommendations of the governing body, based on the recommendations of the selection committee, departmental promotion committee, duly constituted. So it makes also the same thing. B, the director shall communicate his orders within 30 days. Here, time frame is laid down. It is made so specific and direct that it leaves no scope to interpret otherwise. That when the recommendation is made, selection was made by the selection committee, advertisements were issued, selection was made, then recommendation comes, you have to issue the appointment order. And here, you cannot take more than 30 days. Within 30 days, you have to issue the appointment order. That being the position, there is no other rule I find in this respect. These are the rules and provision of law we have seen in the Act. Whether the director was justified to deny appointment order, whether this plea of the director that there could not have been a panel of 3 candidates, and once the first one was recommended and it was rejected for or gone for some reason, panel got exhausted. What is the rule? What is the law? Is it fair? Is it a just rule? That your lordship will have to consider now. On the contrary, lordship will find that in these rules under the 2005 Act, there is no any procedure laid down. Nothing has been said regarding the panel, preparation of the panel. Nothing has been said that you confine only to 1 or you can go to up to 3. Nothing has been said. That being the position, we have to understand that the normal proposition, normal jurisprudential thought in the service jurisprudence is that 1:3. Minimum selection 1:3. And that principle finds place already in a rule made by the same government. It is holding the field even now. That lordship will find at page 48, sorry, 693. 693, the Assam Education Department Selection Rules 1981. at page 693. These were notified in 10th June 1992. These rules, those are the rules made Lordship will kindly come to here. Page 696. Rule 10. Rule 10, publication of select list. The selection board shall prepare list of selection candidates for lecturers and principals numbering at least 3 times of the existing vacancies and shall forward the list so prepared to the government. The government may approve of the list so prepared by the selection board after proper verification of the character and antecedents and publish this list in the official gazette. The list of lecturers should be published subject-wise, and the Director of Higher Education shall forward the list for candidates for principal and lecturers approved by the government to the governing bodies of aided colleges. So, my lord, this is the rules made under Article 309 by the government, and it was regarding selection. What it says that these rules may be called the Assam Education Department Selection. So it was amended up to date. It shall come into force. So it provides for a selection board. It provides for a selection board, and then the duties of that selection board to select the principals, college teachers, lecturers, their selection, how to be made, all that is there. It was provided there. And here also, this principle was incorporated that a select list should be prepared and at least 3 times the existing vacancy, a panel should be there. This principle was already accepted. Now under the 2005 Act, rules made, 2010 rules, but no any such provision has been incorporated. There is nothing saying that only one post, one candidate should be recommended in one selection. It also doesn't say anything about that you cannot recommend 3 candidates. Therefore, it is open, and the normal principle will be applicable, and it is always advisable and fair to recommend a panel. It may be 2 or 3, but it cannot be only 1. Always in such public employments, when selection is made, the recommended panel is always of minimum 2 and maximum 3, normally in all cases. Therefore, this principle was founded on that principle in 1981 rules. 3 times of the existing vacancies, this was there. So, the now, at this stage, I will draw your lordship's attention to their affidavit. Government affidavit, it was filed on 8/2/23, my lord. By the Director of Higher Education. First few paragraphs, they have narrated the facts. Those are already on record. Now, in paragraph 8, they have mentioned, quoted the law. Rule 5 has been placed. Rule 6, Section 6 has been quoted, that I have already placed it. They have also at page 81, running page 81, my lord. They have mentioned at paragraph 7 that in all these cases, governing body shall conduct that has been quoted. Sub-rule 7 has been quoted. Then rule 7 has also been quoted, as Lordship has already considered that. Appointment by direct recruitment, promotion and all, that has been quoted. Basis of recommendation, and that within 30 days it should be communicated. That is also at page 81 they have quoted. These rules have been quoted. Now kindly come to paragraph 9. That the deponent begs to state that there is no provision for making a panel waiting list for selection and appointment of any post, including the post of assistant professor under the Assam College Employees Provincialization Act 2005 and the Assam College Employees Provincialization Rules 2010 and office memorandum guidelines issued from time to time for selection of assistant professors of a provincialized college in Assam. As there is no rule requiring the preparation of a panel list, waiting list for selection and appointment of assistant professor in a provincialized college, if the recommended candidate does not join, or if the recommendation and proposal is rejected by the director, it is the duty of the authority of the concerned college to re-advertise the said post. This is what their position is. They would mean to say that since there is no rule requiring preparation of the panel list, wait list of the selected candidates, and once the recommended candidate is rejected or he refuses the offer, then it gets exhausted. That is the point. Then Lordship will kindly come to paragraph 10, that the deponent begs to state that for administrative approval, appointment, financial liabilities in respect of appointment of any post under the government of Assam, if provisions of the Assam Fiscal Responsibility and Budget Management Act, FRBM 2005, are strictly followed. In the FRBM Act 2005, also there is no provisions for making a panel waiting list for selection and appointment of candidates. That the deponent begs to submit that at no point of time the deponent has acted discriminatory, unfair, injudiciously, arbitrarily, unreasonably. So they have defended that. This is the basic two grounds. Now, that question is, they also say that in Assam Fiscal Responsibility and Budget Management Act 2005 should be strictly followed, but in there also there is nothing, no provisions for making a panel waiting list for selection and appointment of candidates. Therefore, they say that the panel could not have been prepared. My respectful submission here, first Lordship will kindly consider. We have given our rejoinder to it. When the rules are silent and that area remains a gray area, that is regarding preparation of a panel by the selectors. How many candidates could be selected by the selection committee? If this question is posed, and when there is no answer in the relevant act or the rules, then as I submitted earlier, the normal principles should be followed, that 1:3. This is in service jurisprudence. Not single candidate is never selected. Minimum 2 or 3. That is always there. And here this lacuna was filled up by issuing the guideline, the instructions by the director himself. As I have already placed that my writ petition in their letter asking me to advertise the post and make a selection of candidates, there the authority has already mentioned at page 27, I have placed it, but Lordship has noted it, that you go for 3 candidates, make a panel of 3 candidates, so that repetitive advertisements can be avoided. It will entail more cost, time, energy, money, anything. So you go for, if there are candidates, eligible, suitable candidates, you can choose up to 3. Therefore, the authority here having found that there are suitable candidates, the selection committee selected and panel of 3 candidates were prepared. First candidate refused the offer, second candidate virtually refused the offer ultimately. So one remained. So that is the valid select list. How can they say that no, this is not a valid select list? And kindly see one more aspect. When the second candidate's name was forwarded, they rejected it on the ground that no NOC has been submitted. That time it was not raised that his name could not have been forwarded because this panel got exhausted. Panel was illegal. They didn't raise this point that time. They rejected the only point that no NOC was submitted. That means that time they never thought that this is illegal or that they could not have prepared the third panel of 3 candidates. Therefore, the entire logic sought to be assigned to their act in bilateral submission is arbitrary, illegal. And question comes to the FRBM Act, Fiscal Responsibility Act. Is it applicable in such cases? Does the act provide for any recruitment procedure? What is this purpose? Kindly see. FRBM Act, here, what should be, let me look into it. Possible, can you see this act? The Assam Fiscal Responsibility and Budget Management Act. The very name indicates that this is regarding fiscal responsibility and budget management act. And it received the assent of the governor on 13th May 2005. 13th May 2005, it received the assent of the governor, and Lordship may meanwhile also note that this act of 2005, Assam College Employees Provincial Act 2005, this was enacted in December 2005. It got the governor's assent on 19th December 2005, and it was notified on 23rd December 2005. This act is prior FRBM, and this was later point of time. Had there been any occasion to apply provisions of this act in this process of selection and all, that could have been very well incorporated here. That could have been very well mentioned here. There is nothing. It doesn't refer to the FRBM Act. There is nothing here that the provisions of FRBM Act should be applied or would be followed. Nothing is there. And then, Lordship will see here, what is the purpose? It says, to provide for the responsibility of the state government to ensure fiscal stability, sustainability, improve efficiency, and transparency in management of the public finances of the state, enhance the availability of resources by achieving sufficient revenue surplus, reduce fiscal deficit, and remove the impediments to effective conduct of fiscal policy and prudent debt management for improving the social and physical infrastructure and human development in the state, be it enacted by Assam Legislative Assembly in the 56th year of the Republic of India as follows. So kindly see, the whole purpose is different. It is to reduce the fiscal deficit, very categorical, and see to achieving sufficient revenue surplus. There will be no wastage. This is how budget should be managed. The finance should be managed so that the expenditures can be reduced, wastage can be reduced, it can be controlled and managed, regulated. This is the very purpose. And you want that only one candidate in every selection and go on repeatedly advertising, spending money? Two is quite opposite. The whole purpose is different here. And therefore, you should strictly follow that as far as practicable, all selections in one go, one should be finished. There should not be repetitive process. That is, and they want to bring in this now to content that they should have avoided, they should have gone for further advertisement. Well, I find it total misappreciation here, non-application of mind or misappreciation on the part of the authority. How can they apply this act there, which has already been held by a division bench of this honorable court that this is not applicable in such cases. Court as an principle দেখাইছেন কোনবা এনেকুৱা কথা এটা হ'ব এখন একটা কোনটো কৈছে They are relying on here page 9 lordship will come to this act probably my page and lordship act FRBM Act. Section 7 lordship will kindly come. Section 7.
Yes.
It says measures to ensure fiscal discipline. Let us read this. With a view to ensuring timely discharge of current liabilities, especially payment of salaries to the employees, the state government or the appointing authorities under it shall give appointments only against a sanctioned post, which is vacant and in accordance with the laid down rules, procedures, and orders. It refers to the rules, procedures, and orders. And it says only to the extent that appointment should be given only to the sanctioned post. Very rightly. Because unsanctioned post, ad hoc, in charge, all that causes expenditure from the budget, but there is no post, nothing. Therefore, to restrict that, it has made that, yes, only against sanctioned post, and that must be done in accordance with law or the rules. So rules are referred to, law is referred to, that will apply, not this act. Explanation. The appointing authorities under this clause shall include the appointing authorities of the autonomous bodies, including public sector undertakings, companies, statutory bodies, trusts, societies, and cooperative societies under the state government. B. Notwithstanding any other provision contained in any act or rules, no new post shall be created in any department of the state government or in autonomous bodies, including public sector undertakings, companies, statutory bodies, trusts, societies, and cooperative societies, which are under the state government without the prior concurrence of the finance department. No appointment shall be made by the state government or the appointing authorities under it in the vacancies arising out of transfer and leave of the incumbents in this post. No appointment shall be made by the state government or the appointing authorities under it in a post in anticipation of its falling vacant in future. The state government or the appointing authorities under it shall not make more than one appointment against one vacant post The question, we were required to make a law on this ground that against one vacancy you cannot appoint two. When it is to be understood in a civilized society that when there is only one person, one appointment can be made. You see the unfortunate state of affairs in a civilized society like ours. We have to prohibit by making a law. That means there were instances where against one post, 300 people were appointed at times. That is how litigations were. So many inquiries, people are now suffering, coming, and the characteristic of our officers. This is what was going on here. And we claim we are civilized in this 21st century. We take shame on it, my lord. This is our plight. State government, my lord. The state government or the appointing authorities under it shall not make more than one appointment against one vacant post. Any letter of appointment to any vacant sanctioned post shall clearly indicate the identity of the post in the manner as may be prescribed. Next, G. Notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacant sanctioned posts shall contain names equal to the number of vacant posts notified at the time for calling for applications for filling up the post. Here we'll pause, my lord. They might try to bring in this particular provision. Notwithstanding any other provision contained in any act or rules, they have set aside, put aside other rules and acts. The select list prepared for the fresh appointments to vacant sanction posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. Here they say that equal, that means to understand that against one post, only one selection. This way, against one post, only one selection. Names equal to the number of vacant posts notified at the time of calling up the application. This provision in my responsible submission, as has been held by our High Court already, that cannot have application in the recruitment process. There will be no fair selection if we strictly confine to only one. For ensuring that a fair opportunity of equal treatment is given to everybody and fair selection is made, a panel has to be prepared, because again, the same difficulty, one person in the panel, when he refuses, you have to go again for fresh advertisement. If again second time you choose only one, again he refuses, then you will have to go again. So this purpose, the very purpose at the beginning I read out to your lordship, the object and purpose of this act is different, and this particular provision here made will not have application. This honorable court will read it down that this is not applicable, and as has been already held by our court, that this is not applicable in case of these rules, and more particularly when the 81 rules are prevailing. This act itself says that subject to the rules and procedure. Section 7 itself, which says 7A, the state government or the appointing authorities under it shall give appointments only against the sanctioned post which is vacant and in accordance with the laid down rules, procedures and orders. It doesn't say that subject to sub-rule G, it has not said so. This section 7 doesn't say that subject to sub-rule G, they will appoint. It is not said. Therefore, the purpose for which this enactment was made is totally different. Rather, that purpose would be furthered. That purpose for which this FRBM Act was made, that purpose would be further advanced. If a selection is made allowing a panel of 3 persons. It will stop further wastage of money. Therefore, my responsible submission, my lord, by referring to this act, they cannot claim that this is against this particular law, when the act itself provides also refers to the rules and regulations under the respective field, holding the respective field. Therefore, I will place now the decisions before your lordship. Lordship will kindly take up this 2013 1 GLR 345. Dr. Ajit Kumar Bora and others, State of Assam. Kindly come to paragraph 43, my lord. Here, my lord, lordship may before that, I will also point out paragraph 34, where this point was raised, FRBM. Paragraph 34. Mr. Goswami, learned counsel for the appellant petitioners, placed reliance on the decision of the apex court in Mohammed so and so, to emphasize that when the statutory rules are there, the vacancy will have to be filled up only according to said rules without taking recourse to FRBM Act. So this decision is very clear. Here it was said that have to be filled up only according to the said rules without taking recourse to FRBM Act. That submission was made. Now come to 43. As regards the applicability of FRBM Act 2005, on the basis of which the select list had been restricted to candidates equal to the number of vacancies, suffice it to say that provision of the said act cannot be applied beyond the object sought to be achieved by the act. The act was promulgated as a measure of financial discipline. Applying the provision of the said act, the authority could not have restricted the right of consideration for empanelment with eventual selection for the post of principal of college. Moreover, while doing so, the authority could not have overlooked the provision of Section 6 of 2005 Act. We have already taken note of Section 6, my lord. As per the said provision, respective colleges are the selecting and recommending authority for appointment to the post of principal. Therefore, my lord, it says that this FRBM Act has no application in the instant case in such matters, and particularly when it is the responsibility of the colleges for selecting and recommending the names of the candidate. Here, appointing authority, one point just has come to my mind. Lordship will kindly see FRBM. Well, these measures at Section 7 of the FRBM Act, once again, Lordship will see, this relates to the state government or the appointing authorities under it shall give appointments only against a sanctioned post which is vacant and in accordance with the laid down rules, procedure and orders. So it says the government, state government and the appointing authority. If we strictly apply, then we may have to say that only appointing authority is responsible and the government. But the selecting authority has not been taken care of by this. Here the selection authority is different. Recommending authority is different. College authority has been asked to make selections and recommending it. Under the rules, it is the college authority. College authority. And under the rules, college authority is not compelled to make a selection or prepare a panel of only three. I mean, only one. Under the given Act, 2005 Act or 2010 rules. Rather, 2010 rules, it says, 81 rules, it says that it can be up to 3 times. Therefore, there is no restriction on their part. The question would be finally asked whether the panel was rightly prepared. That is the basic question. There is no now quarrel on the point that the selection was not legally made, procedure was not followed, selection was not fair. That was not the point raised. Point raised, finally, when the second candidate also didn't turn up, that third candidate could not have been. Up to second, they didn't raise objection. Up to second, they didn't raise objection. That all these objections now they are raising, those were not raised that time. Now, when the third and last candidate was recommended, they are taking the point, which were relevant to the second also, in case of second candidate also. That was not done. Therefore, my respectful submission, these provisions of this FRBM Act cannot be applied as has been held by this Honorable Court in that judgment we have already placed. And all such selections must be carried out under the given set of rules. And that having been done, they are having found no irregularity or illegality in the process of selection. Panel being legally prepared and authority is bound to act. And panel of 3 candidates cannot be a ground to deny appointment to me as I was selected in accordance with the rules. Another decision at 2019, 1 GLT, page 87. This was also division bench decision decided on 22nd of May 2018. It is regarding the selection and appointment of Assam College Employees Provincial Election Rules 2010. The same question came up. Lordship will kindly come to paragraph 10. The procedure for making direct recruitment to the post of lecturer in the provincialized colleges in Assam has been laid down in the rules of 2010. As per the Rule 7 of the Rules of 2010, all appointments by direct recruitment is to be made by the director on the basis of recommendation of the governing body based on the recommendations of the selection committee. Rule 5.7 provides that it is the governing body which shall conduct the selection process and make recommendations of the to the director who shall issue orders of appointment. From the aforesaid provisions of the rules, it is apparent that the responsibility to conduct the selection and make recommendations of the candidate for appointment lies with the governing body, whereas the power of the director is confined to issuing the order of appointment. Therefore, my lord, my respectful submission is the ground now the director has taken are not sustainable in law. None of these 2 grounds are sustainable in law. Therefore, the petition has to be allowed with a direction to issue appointment orders immediately, because the college is suffering, students are suffering. Individually, I am also suffering, waiting for an appointment. I cannot decide what to do, what not to do. I am waiting for justice. They fail to give me justice. And I am to come before your lordship for my redressal, and my responsible submission will be that direction should be issued immediately to issue appointment orders. That is my responsible submission. What they say, if necessary, I will reply to it. Oblige.
May please, your lordships. To lordship decide the issue, lordship. I pray before your lordship to frame two moot question, lordship, and I will confine my argument within that two question, lordship. If that question answers goes against me, then petition will be allowed, lordship. If that question answered in favor of me, then lordship, then I have no case, lordship. So, lordship, first question is, lordship, whether the authority can prepare a panel list, access the push advertised, lordship, and whether the authority can act upon this, lordship. And second one is, lordship, whether the letter dated 27/6/2017 is legally enforceable when there is a statutory act and rules, lordship. That particular two questions I will argue on the basis in confined to the above two questions, lordship. First of all, lordship, the advertisement was issued, lordship. Kindly peruse the advertisement, lordship. Advertisement is page 23, lordship. Page 23, lordship. Page 23, lordship. Last portion, lordship. Page 23. Type copy is page 22, lordship.
Yes.
Page 22, lordship. Last, lordship, serial number 1, lordship, assistant professor of political science, 1 post reserved for SC. My lord, may kindly mark it. 1 post was advertised, lordship, for a post of political science, lordship, reserved for SC, lordship. Now, lordship, Sunari College. Sunari College is a provincialized college under the 2005 Act, lordship. So, in respect of the employees in the Sunari College, lordship, the Act of 2005 and Rule of 2010 is applicable. My lord, may kindly note it. The Act which was mentioned, lordship, in page 693. Lordship, may kindly page 693, lordship.
Yes.
92 question, no? It's 93, lordship. The Assam Education Department Selection Rules 1981, lordship. Whereas it is expedient to amend the Assam Education Department Selection Rules 1981, regulating to the method of selection of principal and teachers of aided college, lordship. Kindly, lordship, mark it. Aided college, lordship. Aided college notified by so and so, lordship. This rule was applicable, lordship, at the time of when the college was granting aid under the government of Assam, lordship. This rule has no at all applicable in the present case, lordship. And nowadays also there is no any aided college of the government, lordship. Colleges are provincialized under 2005 Act, which was earlier under the deficit granting system of college, or otherwise which are another aided system of the college, lordship. That part is already gone, lordship. That particular rule is not in force at that. Today there is no any force in the particular rule, lordship. When the college was in granting aid system, that particular rule was applicable. Sunari College was also in the granting aid system. That college was provincialized by operation of the law of Act 2005, lordship. Now 2005 is applicable, lordship. Though there is a provisions for selection or preparation of select list in 1981 rules, lordship, that rule is not applicable in this case, lordship. That rule was applicable in the when the college was in the granting aid system. So that particular rule is not applicable. The provisions contained in that particular rule is not applicable here, lordship. Now, lordship, Here Lordship 2005 Act and 2010 rules is applicable Lordship. So Lordship may kindly come to 2005 Act Lordship. Act Lordship. Definition clause kindly come Lordship. Definition clause. College Lordship. College means any non-government college in Assam in receipt of deficit grants in aid from the government and imparting general education, arts, science, commerce, science, history on the graduate level Lordship. Those colleges who were under the 1981 rules, that colleges were provincialized under this act Lordship. So that 1981 rules is not any evidentiary value and here Lordship. Here rule 6 is section 6 Lordship. Section 6 stipulates the provisions for Lordship selections and appointment of employees Lordship. Section 6 says that Lordship, appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective college in accordance with the rules and procedure in the government in force Lordship. Now what is the rules Lordship? Rule was Lordship under section 12 Lordship. Section 12 is the rule making power Lordship. Power of the government to make rules Lordship. In exercise of the power Lordship given under section 12 Lordship. Section 12 is Lordship 495. In exercise of the power Lordship under which was under section 12 Lordship, the 2010 rules was enacted Lordship. 2010 rules is 496 page. 496 Lordship. In exercise of powers conferred under subsection 1 of section 12 of Assam College Employees Provincialization Act 2005, the Governor of Assam is hereby pleased to make the following rules for carrying out the purpose of the said act Lordship. This act is applicable Lordship. This rule is applicable for the colleges which were provincialized under the 2005 Act Lordship. This rule is applicable Lordship. That particular rule which was referred in 1982 rules is not applicable here Lordship, where there was a provisions for penal list Lordship. So Lordship, the method of recruitment is Lordship Rule 5. Here the post is lecturer or assistant professor. So Lordship 5.2 is the relevant Lordship. For the post of lecturer, librarian, appointment shall be made by the direct recruitment with prescribed qualification to open advertisement into leading dailies at least in 2 consecutive issues Lordship. Here is the direct recruitment Lordship. Then Lordship 7. In all the cases, the governing body shall conduct the selection process and recommend to the director who shall issue the order of the appointment Lordship. The duty of the governing body is to conduct the selection process and recommend Lordship. Then it is the duty of the director to Lordship issue the appointment order Lordship. Then Lordship, direct recruitment 7 Lordship. All appointment either by direct recruitment or by promotion shall be made by the director on the basis of the recommendation of the governing body, based on the recommendation of the selection committee, departmental promotion committee duly constituted. The director shall communicate his orders within 30 days. The selection committee may hold such test or interview for the post as may be considered necessary. For the post for which UGC has prescribed norms, no candidate shall be recruited without having the required norms Lordship. All fresh appointments shall be made on receipt of the police verification report Lordship. Other provisions is also there Lordship. Age limit and qualification, general procedure for promotion, selection and departmental promotion committee Lordship, reservation, training, probation, confirmation, discipline appeal, scale of pay, seniority, gradation list, transfer, maintenance regards of record, GPF and pension, leave and deputation, study leave, NOC Lordship, authority to acceptance, resignation, and SCR and residuary power of the appointing authority Lordship. The rules Lordship nowhere reflected. There is no any provisions regarding preparation of the penal list Lordship, as it was in the 1982 rules Lordship. 1982 rules Lordship, there is a provisions Lordship. There is a specific provision for preparation of the list Lordship. Penal list up to 3 Lordship. In this particular rules, Lordship, there is no any provision, Lordship. The intention of the legislature is very clear, Lordship. The intention and the statute itself, Lordship, indicate that, Lordship, there is no provisions for preparation of the select list. Lordship. If there is a provisions for preparation of a select list, then it will be there, Lordship. It will be incorporated here, Lordship. That particular provision was incorporated here. It is, Lordship, clearly we can bring it from 1982 rules, Lordship. 82 rules clearly indicate that there should be a panel up to 3, Lordship. And these particular rules, which is applicable in the petitioner's case, that provision was absent, Lordship. So, Lordship, the Act and rules, Lordship, here prohibits for preparation of the panel list, Lordship. You have to select the selected candidate and you have to forward it, Lordship. After that, if you not join or you don't want to join, Lordship, or otherwise rejected that proposal, it should be the college authority to re-advertise and re-advertise the same, Lordship. Because the authority, appointing authority wants the best of the best candidate, Lordship.
Only one question is there.
Lordship.
When the first person
Lordship.
rejected the offer,
Lordship.
second person's name was put up.
Lordship.
You did not make anything, any
Lordship.
complaint.
Lordship.
However, you rejected the,
Lordship.
since he has not submitted the NOC.
Lordship.
Correct?
Lordship.
He was rejected.
Lordship.
Now, when the third name is proposed,
Lordship.
why are you keeping silent?
Lordship, third name.
Are you not supposed to act?
Lordship.
Is the director not supposed to act?
Director is supposed to act, Lordship. That one particular petition was pending, Lordship. This was withdrawn recently, Lordship. That's why, Lordship, the final exercise was not done by the director. And in the meantime, Lordship, they have filed the petition, Lordship. And if I go by my Lord judgment, then it should be treated as a premature case also. Because the director has yet to take a final decision, Lordship. Yet to take a final decision, Lordship.
He's sitting over the file.
Sitting over the file is not, Lordship. It is sitting over the file only because of that there was a court case is pending, Lordship.
When was the case?
Case is disposed of recently, Lordship. It was withdrawn recently, Lordship. 11/3/2022, Lordship.
11/3/2000.
Lordship.
2018. It was filed on 2001 1355/2018. And the order was passed, and thereafter
Withdrawn on March of 2022.
Lordship.
So, and you're waiting for another what, 12 months?
Lordship, that part today I cannot.
It was filed 2018.
That is
Oh,
fine.
withdrawn.
After the case is withdrawn.
Lordship.
Or after the case is closed. That was in March 2022.
Yes.
Director is waiting for another 12
Withdrawn,
months.
Lordship, they have sent again proposal on 23/5/2022. 23/5/2022, they have again sent proposal, Lordship. 25/2022.
That was more like a reminder.
And Lordship, the particular writ petition is filed on 20 June 2022, Lordship.
What you can do.
Case
is you
was
could have
withdrawn.
Acted on the file.
Case was withdrawn on March, Lordship. Case was withdrawn on March, Lordship 3. On Lordship 11/3/2022. And the college has sent proposal of Lordship 23/5/2022 by giving a reminder to act upon the earlier recommendation which was sent before filing the writ petition 2018, Lordship. They have sent it on 23/5/2022 and they have approached the Honorable Court, Lordship, kindly peruse page 21. Page 21 is 20 June 2022, Lordship. That,
So what I'm saying.
Lordship,
When the second proposal was sent.
Lordship,
You rejected it straight away.
Lordship.
Saying that no,
Lordship.
since he did not give his NOC,
Lordship.
his case is rejected.
Lordship,
In this third proposal,
Lordship,
okay, we understand that there was an interim order.
Lordship.
But then it was
It was on
closed on 11th of
March,
March
March.
2022.
Lordship,
You're waiting for another 12 years doing nothing. You could have
12
rejected the matter.
12, no, it is not a question of 12 months, Lordship. After
You could have
rejection,
rejected the matter.
rejection of March, withdrawal of that particular writ petition on March, Lordship, the reminder was sent on 22 22-5, Lordship.
Correct.
27, 22-5, Lordship.
After you got a reminder.
25, Lordship, and immediately they have preferred the repetition, Lordship.
Is there any bar in the repetition that the?
There is no any bar, Lordship.
Cannot take any-
Basically, when a case is pending, Lordship, the authority don't want to take any decision, Lordship. In every cases, even my Lordship, every cases, Lordship.
No, this is not always correct, man. My submission, my learned friend is not always correct.
I will place after that, my senior sir will
No,
reply.
This is what the query has come from this honorable court. So I am to clarify, because I am witness to this. Even in this court also, when the appeal was pending, appeal was filed, immediately thereafter, appointments were made. And then the court has to again pass an order that will accommodate these people also. So it created chaos. This happens, knowing it well that the case is pending, everything done. So always it is not followed. In some cases, yes, maybe, but not always.
This is the reason, Lordship. Now, Lordship, I have to satisfy whether the panel list can be prepared or not, Lordship. We have file affidavit, Lordship. We have file affidavit. Paragraph 9 and 10, Lordship. Again, I am reiterated paragraph 9, Lordship. Paragraph 9. That the deponent begs to state that there is no provision for making a panel waiting list for selection of the appointment of any post, including the post of assistant professor under the Assam College Employees Provincialization 2005 and the Assam College Employees Provincialization Rules 2010 and the Office Amendment guidelines issued from time to time for selection of the assistant professor of a provincialized college in Assam. As there is no rule requiring for preparation of the panel list or waiting list for selection and appointment of assistant professor in the provincialized college, if the recommended candidate does not join or if the recommendation of the proposal is rejected by the directorate, it is the duty of the authority of the concerned college to re-advertise the post, Lordship. Then again, paragraph 9, Lordship, that the deponent begs to state that for administrative approval, appointment, financial liabilities in respect of appointment for any post under the Government of Assam, the provisions for Assam Fiscal Responsibility Budget Management Act, FRBM Act 2005 are strictly followed. In the FRBM Act 2005 also, there is no provision for making a panel or waiting list for selection and appointment of the candidate. Basically, these two grounds, Lordship, we are not able to consider the petitioner's case. Now I have to satisfy whether these two grounds can be survived, whether two grounds can be taken by the authority as per the judgment of the Honorable Apex Court, Lordship. I will rely on the Honorable Apex Court judgment and place it. Before that, Lordship, before going to that, Lordship, FRBM Act, Lordship.
I have.
Lordship. Lordship, kindly section 7, Lordship. Before section 7, Lordship, Lordship may definition clause, Lordship.
Which?
Definition clause of the FRBM Act, Lordship.
Yes.
FRBM Act, definition clause, Lordship, appointing authorities. Appointing authorities means officers of the state government exercising the delegated authority of appointing persons to the post of the state government, Lordship. Then my lord may kindly come to next page, Lordship. After the explanation part, Lordship, sanction post. M, Lordship, M.
Yes.
2M, Lordship. Sanction post means the post which were created by a sanction of the state government and has not been subsequently abolished or kept in abeyance in order of the state government, Lordship. Here also, Lordship, the particular post is created by the government of Assam, Lordship. Gov creation number is also there, everything is there, Lordship. Then my lord may kindly come to Lordship 7, Lordship, section 7, Lordship. with a view to ensuring timely discharge of current liabilities, especially payment of salaries to the employees, the state government or the appointing authorities under it shall give appointments only against the sanctioned post which is vacant and in accordance with the laid down rules, procedure, and orders. Lordship. The FRBM Act clearly states that, Lordship, as per the laid down rules, procedure, and orders. Here, what is the rules, Lordship? The rule is 2010 rules, Lordship. Then, Lordship, G. Notwithstanding any other provisions contained in any act or rules, the select list prepared for the fresh appointment to vacant sanctioned posts shall contain names equal to the number of vacant posts notified at the time of calling for appointment or the filling of the post. Now, Lordship, what is the number of the vacant posts here? Only one post reserved for SC, Lordship. So the particular select list or panel should be the one candidate, Lordship, as per the FRBM Act, Lordship. Then, Lordship, kindly come to next page, Lordship. Next page, section 8, Lordship.
Yes.
Offense and penalties, Lordship. Whoever violates any or more of the provision of section 7 shall commit an offense which shall be punishable with rigorous imprisonment for a term which may extend to 3 years, Lordship. The terms and conditions which are given under section 7, if any officers or appointing authority violate any provisions, Lordship, it should be treated as a criminal offense and, Lordship, punishment imprisonment up to 3 years, Lordship. Whoever causes financial loss to the state government willfully or with malified intention by under assessment and or under realization of revenue due to the state government and or by incurring unauthorized expenditure shall commit an offense which shall be punishable with rigorous imprisonment for a term which may extend to 3 years or recovery of the amount. A person who abets any of the offenses as aforesaid shall be liable for the same punishment as provided for the offense. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the offense committed under this act shall be treated as a cognizable offense. Offenses under this act shall be triable by a magistrate not lower than the rank of a judicial magistrate of first class, Lordship. This is the penal provision, Lordship. If any appointing authority violates the provisions, Lordship, which was given under section 7 of the FRBM Act. What section 7 says? Section 7G says the penal list should be the equal number of the vacant post which was advertised at the time of advertisement, Lordship. Here is also post is 1, Lordship. So the college authority cannot prepare a T number of persons, Lordship, the penal list by violating the provisions, and in that particular penal list, the appointing authority cannot act upon, Lordship. If appointing authority act on the basis of that particular penal list, they will, Lordship, face the consequence of section 8, Lordship. Our hands are tied, Lordship. We cannot act upon the penal list prepared by the authority, Lordship, which is not permissible under the law, Lordship. Now, Lordship, my senior sir and Guru says, he is my Guru also, Lordship. My Guru says that, Lordship, that the act, there is no provisions, Lordship, regarding preparation of select list, Lordship. There is no provision, Lordship, regarding preparation of select list. So, Honorable Apex Court has laid down the law where there is no provision of preparation of panel list or waiting list, Lordship. Then the preparation of the preparation of the panel list is not tenable in the eye of law, Lordship. Recent judgment I will place, Lordship. I am starting, Lordship, one judgment from 2004. 2004 judgment could be second copy to almost as well, nothing. 2004 Lordship, 2004 to SCC 681, had no, thus I am pointed out Lordship. Service law, recruitment process selection, panel select list, panel slash select list slash waiting list in the absence of statutory rules to the contrary, the employer held not bound to prepare a waiting list in addition to the panel of selected candidates and to appoint the candidates on the waiting list on the candidates of the panel do not join Lordship. Paragraph 6 and 7 Lordship. Findings. We find merit in this appeal preferred by the board. In the case of so and so, it has been held by this court. Even if number of vacancies are notified for appointment and even if adequate number of candidates are not found fit, the successful candidate do not acquire any indefeasible right to be appointed against the existing vacancies. That ordinarily such notification merely amounts to an invitation to a qualified candidates to apply for recruitment, and on their selection, they do not acquire any right to the post. It was further held that the state is under no legal duty to fill up all or any of the vacancies unless the relevant recruitment rules indicate. In the present case, we are not shown any such relevant recruitment rules. Moreover, there is no merit in the contention of the advance on behalf of the respondent number 1 to 7 that the appellant had violated the order of the High Court dated so and so by preparing a list of only 22 candidates instead of filling up 50% of the alleged 161 vacancies. In this connection, the impugn judgment of the High Court has recorded a finding of the fact that board has rightly reduced the number of vacancies to 50 to the extent claimed to the writ petitioners was rejected. In the impugn judgment, the High Court found that 50 vacancies were required to be filled up, 25 against the advertisement dated so and so and 25 against the advertisement dated so and so. However, according to the impugn judgment, the appellant ought to have made appointments by preparing a further panel of 18 vacant posts which become vacant when the earlier 18 selected candidates opted out. In this part, the reasoning of the High Court which is fallacious. Honorable High Court says that, Lordship, the 18 candidate was not joined, so you prepare another 18 list. Then Honorable Apex Court says that the candidates who is to be fill up 25 to advertisement dated so and so, 25 dated advertisement dated so and so. If they are not Lordship joined, then you cannot Lordship prepare another list, Lordship. In the present case, pursuant to the direction of the High Court dated so and so, the appellant took steps for filling up 25 vacancies in the post of operators from advertisement dated so and so. The remaining 25 vacancy for advertisement dated so and so. The result were notified on so and so on the notice board. The government recommended names of successful candidates under advertisement dated so and so out of 22 candidates selected by the board for appointment under advertisement dated so and so did not turn up. At this stage, it is important to note that respondent 1 to 7 had applied for appointment under advertisement on so and so, and they had qualified, but they were placed at serial number 23 onwards in the descending orders. As stated above, a panel of 22 candidates was prepared for appointment under advertisement dated so and so, and respondent number 1 to 7 fell beyond the cutoff number. We are not shown any statutory recruitment rules, Lordship. My Lord, may kindly mark it, Lordship. We are not shown any statutory recruitment rules. We require the appellant board to prepare a waiting list in addition to the panel, Lordship. My Lord, may kindly mark it, Lordship. Here, the panel should be 1, Lordship. The argument advanced on behalf of the respondent number 1 and 7 was in effect that when 18 candidates failed to turn up, the appellant was bound to offer post to the candidates on the waiting. No such rules has been shown to us this regard. In our view, the judgment of this court in the case of so and so squarely applies to the facts of the case. Further, there was no infirmity of the judgment of this court dated in our view. With respect, there was no need to recall the said judgment, Lordship. This is the recent judgment of the Honorable Apex Court Lordship.
Which one?
First Lordship, Bhalampati Satish Babu Lordship, State of Andhra Pradesh Lordship. Citation to sir 90. Monu SC 049022. Here, Lordship, I am relying paragraph 4.4 onwards, Lordship. Paragraph 4.4, Lordship. 4.4, 7.4, Lordship. 8.1, Lordship, and 4.4, 7.4, 7.5, 8.1, and 9, Lordship.
Yeah.
Lordship. 4.4. Relying upon the decision of this court in the case of Bihar State Electricity Board and Suresh Prasad, just I am relying, Lordship, the judgment, Lordship. It is vehemently submitted by Siri So-and-so Learned Counsel appearing on behalf of the respondent state that as held by this court in the aforesaid decision, where the rules do not envisage drawing up a waiting list, no waitlisted candidate could be appointed as a result of non-join of the selected candidate, Lordship. 7.4, Lordship. In the present case, 7.4, Lordship. In the present case, the final selection list of 33 candidates was prepared. Thereafter, all the selected candidates were called for counseling, but one of the candidates did not report the counseling. The aforesaid event took place after the final selection list was prepared and published. As there was no requirement of a preparation of a waiting list, the appellant claiming to be the next in the merit cannot claim any appointment as his name neither figured in the select list as a selected candidates nor in any waiting list, as there is no provisions to all for preparation of the waiting list. Sub rules 5 rule 16 is very clear. Therefore, the post remain unfilled due to one of the candidates in the final list did not appear for counseling and or accepted the employment. Hence, the post has to be carried forward for the next recruitment, Lordship. Here also the similar case, Lordship. If the Lordship, the candidate which is not joined or Lordship, he rejected the offer of appointment, Lordship, it should be for the direct, again it should be advertised for the post, Lordship. 7.5, Lordship. The appellant could have claimed the appointment to the post which remain unfilled provided there is a provision for waiting list as per the statutory provision. In absence of any specific provision for waiting list or on contrary, there being a specific provision that there shall not be any waiting list and the post remaining unfilled on any ground shall have to be carried forward for the next recruitment, the appellant herein does have no right to claim any appointment to the post which remain unfilled. Here also, Lordship, in our statute, Lordship, there is no provisions for preparation of the panel and waiting list, Lordship. So, Lordship, if the candidates which are selected not joined or otherwise rejected, Lordship, then there is no questions for the taking up the below candidate or third one or fourth one, Lordship. 8.1. An identical question came to be considered by this court. In the case of Suresh Prasad so-and-so, in the said decision, it is specifically observed and held that even in the case candidates selected or appointed have not joined, in absence of any statutory rules to the contrary, the employer is not bound to offer the unfilled vacancy to the candidate next below to the said candidate in the merit list, Lordship. This is the ultimate findings of the Honorable Court, Lordship. It is also further held that in absence of any provision, the employer is not bound to prepare a waiting list in addition to the panel of selected candidates to the appointing candidates from the waiting list in case of candidates from the panel list not joined. The aforesaid decision of this court has been subsequently followed by the Andhra Pradesh High Court in the cases of so-and-so, so-and-so. 9. Applying the law laid down by this court in the case of Suresh Prasad and others to the facts in the case in hand, the considering the statutory provision contained in Rule 16 and Rule 22, read with the guidelines, we are of the view that appellant cannot claim appointment to the unfilled vacancy, being next below the candidate in the merit list, If the submission on behalf of the appellant is accepted, in that case, it will lead to providing a preparation of a waiting list in which otherwise is not permissible as per section so and so. If the same is permitted in the case, it will be directed respondent to act contrary to the statutory provision. Here is also, Lordship, in our statute, Lordship, there is no provisions for, Lordship, preparation of the select list, Lordship, or waiting list, Lordship. Next one, Lordship. The state of Uttar Pradesh versus Karunesh Kumar, Lordship. It was decided on 12/12/2022, Lordship, and authored by my Lord Justice M.M. Sundaresh, Lordship. Here, yes, here, Lordship, I am relying, Lordship, paragraph 7.4, Lordship. It is the internal paragraph of 30, Lordship. 30, Lordship. By relying the proposition laid down in the earlier case, which just I have read out, Lordship, the Honorable Court, Lordship, ultimate finding is that, Lordship, if there is any rules, Lordship, provisions, so we cannot, Lordship. That is, Lordship, in paragraph 30, Lordship. Paragraph 30, I am not reiterated, Lordship. The basic, Lordship, the law laid down by the Honorable Apex Court is that, Lordship. If there is no provisions in the Act and rules for preparation of a select list or wait list, Lordship, we cannot act upon the wait list or select list which will be prepared or which will be prepared, Lordship. If the particular candidate is not joined or the recommendation of the particular candidate is rejected by the authority, Lordship, then the best course is the college authority has to re-advertise it, Lordship. We cannot go for the second one, third one, or fourth one, Lordship, or it cannot be, Lordship. Now, Lordship, the letter which was in page 27, Lordship. Page 27. Page 27. Type copy starts from, Lordship, page 24, Lordship. No, I don't know. Yeah, I don't know. Yes, this one. Page 24, Lordship. Page 24, that particular letter was issued by one of our director, Lordship. Page 26, Lordship, where it is written that in the event of first candidate joining elsewhere or not offering to join, the appointing authority may go for preparation of a select list up to the candidate number 3, comparative statement to the same post. It is a letter issued on 27/6/2017, Lordship. Whether that letter is, Lordship, holding the field or whether that letter can, Lordship, substitute the provisions of the statute, Lordship. This particular letter was written by one of the officers of the Higher Education Department, Lordship, which is beyond the authority or beyond the jurisdiction prescribed under the rules and act, Lordship. It is not a letter issued, not a office memorandum or nothing else issued by the governor, Lordship. That particular letter was issued by the director, Lordship, by violating the statutory provisions, Lordship, which were stipulated in Act of 2005 and 2010 rules. Now, I have to submit before the court, Lordship, whether that particular letter has any legal value, Lordship. Whether we can act upon that particular letter, despite that our rules prohibit for preparation of panel list, Lordship. As per the, Lordship, judgment of the Honorable Apex Court, various judgment of the Honorable Apex Court, and my Lord also deal with similar kind of issues, and I have also gone to my Lord judgment also, Lordship. We cannot, Lordship. We cannot act upon the letter issued on dated lordship 27/6/2017 because that particular letter is not under the any statutory provisions, not under the power conferred under the statutory rules, lordship. It was, no? Here, lordship, this is one of the latest judgment of the Honorable Apex Court, lordship. The Employees State Insurance Corporation versus Union of India and others, lordship. It is reported in lordship AIR 2022 SC 1017, lordship. Here I am relying the citation of the Monu, lordship. The equivalent citation is lordship AIR 2022 SC 1017, lordship.
Yeah.
My lord, may I kindly directly come to lordship, internal page 3. Internal page 3, lordship. Paragraph 6, it is lordship Roman 8. Roman 8, lordship. May I read, lordship?
Yeah.
It is settled law that in the event of an inconsistency or conflict between a statutory provision and an executive instruction, the former must be given effect, lordship. What is the statutory provision here, lordship? The statutory provision prescribes, lordship, nowhere prescribed for preparation of a lordship panel list or select list, lordship. If there is nowhere prescribed for preparation of a panel list and select list, lordship, there is no question of issuing a letter by the directorate that you should consider the candidate up to 3, lordship. This court in Union of India in Ashok Kumar Agarwal reported in so and so has held that government issued memorandum or executive instruction can issue only to supplement the statutory rules, not to supplant them, lordship. Then, lordship, all the judgment of the Apex Court was reiterated here. My lord, may kindly come to paragraph 16, lordship. I am not troubled here, lordship. Just time of 30, lordship. Time is also running, lordship. Paragraph 16. In Union of India versus Ashok Kumar Agarwal, a 2 judges bench of this court speaking to the context of service regulations governing a departmental inquiry reinitiated that an office order or office memorandum cannot contravene statutory rules. Justice B.N. Suhan noted the position of the law in the following terms, lordship. The law laid down above has consistently been followed, and it is a settled proposition of law that an authority cannot issue orders, office memorandum, executive instruction in contravention of the statutory rules. However, instruction can be issued only to supplement the statutory rules, but not to supplant it. Such instruction should be subservient and to the statutory provision, lordships. And lordship, the Honorable Apex Court judgment here quoted, lordship. Then lordship, paragraph 17, lordship. In PD Agarwal versus State of UP, a 2 judges bench of this court declined to grant primacy to the office memorandum issued by the government of Uttar Pradesh, who is purportedly amend the method of recruitment in assistant engineer in UP Public Service Commission without amending the relevant regulation, lordship. The court held the office memorandum dated so and so, which purports to amend the United Province Service of the Engineering Building and Routes Branch Class 2 Rules 1936, in our opinion, cannot override, amend or supersede the statutory rules. This memorandum is nothing but an administrative order or instruction, and as such, it cannot amend or supersede the statutory rules by adding something therein, as has been observed by this court in Santaram Sharma versus so and so, lordship. Here also, lordship, that particular letter issued by the director by contravening the provisions, which is in 2005 and 2005 Act and 2010 rules. There is no provision, lordship. Nowhere it is stated that you should prepare a panel up to 3 as indicated in 1981 rules, Lordship. That rules, there is a clearly statutes indicate that you should prepare a panel up to 3, Lordship. But 2010 rules, that is absent, Lordship. There is no provisions, Lordship. So the director cannot act beyond the jurisdictions, beyond the power prescribed by the rules of 2010, Lordship. In view of the above, Lordship, and on the basis of the Honorable Supreme Court, Lordship, law laid down by the Honorable Apex Court, Lordship, the director cannot, and we also cannot act upon that particular letter, Lordship. This is a settled proposition of law, Lordship. I may not reiterate it also, but I am reiterating, Lordship, for my delivering the argument. I have to reiterate it because, Lordship, the proposition was in the Privy Council, it was already settled. In Nazir Ahmed case, it was settled, Lordship, and it was followed by the Honorable Apex Court, and it was reiterated time to time. And it is one of the latest judgment of the Honorable Apex Court, Lordship, which was delivered on 25/7/2022. And Monu SC 0919/2022, Lordship, Union of India versus Mahinder Singh, Lordship. Here, Lordship, I am relying paragraph 14, 15, 16, and 17. If Lordship permit, I can read it.
Yes.
Lordship. Paragraph 14, Lordship. The argument of Mr. Bhushan that use of defined language is not followed by any consequence and therefore cannot be said to be mandatory is not tenable. The language chosen is relevant to ensure that the candidate who has filled up the application form alone appears in the written examination to maintain and probability. The answer sheet have to be and in language chosen by the candidate in the application form. It is well settled that, Lordship. It is well settled that if a particular procedure is filling up the application form is prescribed, the application form should be filled up following that procedure alone. This was enunciated by Privy Council in Nazir Ahmed versus King Emperor, Lordship, wherein it was held that where a power is given to do a certain thing in a certain way, the things must be done in that way or not at all. Other methods of performance are necessarily forbidden. Here also, Lordship, the rules and act provide the authority to act upon in a certain way, Lordship. We have to follow that particular rules and regulations, Lordship, and act. We cannot go beyond that, Lordship. It is a golden principle of law settled by the Privy Council, Lordship, and which was followed, Lordship, till today by the Honorable Apex Court, Lordship. 15, Lordship. A 3 judges bench of this court in the judgment reported in Chandrakishore Jha versus Mahavir Prasad held as under. It is well settled salutary principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and no other manner, Lordship. Then, Lordship, 16. The said principle has been followed by the court in Serukuri Moni versus Chief Secretary, Government of Andhra Pradesh, Lordship, and whereas the Honorable Court held as under, where the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner, following the provisions of law, without deviating from the prescribed procedure, Lordship. This is the law laid down by the Honorable Apex Court, Lordship. We are bound to follow the law laid down by the Honorable Apex Court, Lordship. Here, the rules and regulation of the Government of Assam Higher Education Department, there is no provisions for preparation of the panel list or waiting list, Lordship. So we cannot act upon the panel or waiting list which was sent to us by the authority, Lordship, college authority, Lordship. The law is well settled, Lordship. We have to done our duty. We have to perform our duty. We have to exercise our power, Lordship, within the 4 corners of the statute or rules, Lordship. We cannot go beyond that, Lordship. So, Lordship, in such view, Lordship, The letter issued by the director on 17/6/2017 is not a legally enforceable document, Lordship. We cannot act upon this, Lordship. If we act upon this, we have to violate the provisions of the law laid down by the Honorable Apex Court, as well as the statutes which is, Lordship, in force in respect of the Higher Education Department, Lordship. Then, Lordship, regarding, Lordship, director's power, Lordship. Here one submission was made that, Lordship, when recommendation was given to the directorate, Lordship, he have to act upon this and he have no option, Lordship. But the Honorable, our High Court has held that, Lordship, the director is not a rubber stamp, Lordship. Before according approval of the governing body or before issuing the appointment order, director should satisfy himself, Lordship, whether that particular selections and recommendation is carried out in accordance with law or not, Lordship. Here I am relying paragraph 12, Lordship. Paragraph 11 also, Lordship. Paragraph 11 onwards, Lordship. I am relying paragraph 11 and 12, Lordship.
Yes.
Paragraph 11. Having noticed the above, it would be opposite to briefly refer to the relevant legal provisions relating to selection of the principals of a provincialized college, Lordship. There is no dispute at the bar that the college is a provincialized college and is governed by the provisions of Assam College Employees Provincialization Act 2005 and the Assam College Employees Provincialization Rules 2010. As per Section 6 of the 2005 Act, appointment of both teaching and non-teaching staff in the college shall be made by the Director of Higher Education on the basis of the selection and recommendation of the governing body of the college in accordance with the rules and procedure of the government in force. 2010 rules have been framed under Section 12(1) of the 2005 Act. As per Rule 5(1), appointment to the post of principal shall be direct recruitment through selection. For the purpose of governing body shall constitute a selection committee which shall select a person on the basis of an interview from amongst the eligible candidates who apply in response to an open advertisement in newspaper. The governing body shall recommend the selected candidate to the director who shall issue order of appointment as per Rule 7C of the 2010 rules. For the post where UGC has prescribed norms, no candidate shall be recruited without having the required norms. Having noticed the scheme of selection for the post of principal in the provincialized college, what is unmistakably in the present case is that the selection process has not yet attained finality. It is only when the director accords approval to the recommendation of the governing body that the selection would attain finality. The aspect of the matter was gone into by this court in the recent decision of Sonali Bora Sohoria versus State of Assam, reported in 2016 5 GLT 260. Disposed of on so and so. It has been held that until the director grants approval to the selection process, no final decision can be said to have been taken in respect of the selection. No definite cause of action can be said to have occurred at such as stage to close an unrecommended candidate as aggrieved party, thereby enabling him to initiate a legal action. Selection by a selection committee or recommendation by a governing body per se would not give rise to cause of action for initiating a legal proceeding. My lord, may kindly mark it. Because no finality is attached to such recommendation at a stage prior to acceptance or non-acceptance by a director. It was held as under. The post of lecturer in college has been redesignated as assistant professor following notification issued by UGC. Recruitment of assistant professor in the college is governed by set of statutory rules called Assam College Employees Provincialized 2010, which has been framed in exercise of powers conferred under Section 12(1) of the Assam College Employees Provincialization.
You can skip that.
Lordship. Then Lordship, ultimate finding is Lordship, paragraph 12. At first blush, it would be appear that once recommendation is made by the governing body, the director has no discretion but to issue order of appointment. Rule 7A provides that all appointments either by direct recruitment or by promotion shall be made by a director on the basis of recommendation of the governing body based on the recommendation of the selection committee. As per clause B of the director is required to communicate his order within 30 days. As per clause C of the rule 7, in respect of post of the UGC has prescribed norms, no candidate shall be recruited without having the required norms, Lordship. Therefore, from a careful and conjoint analysis of the provisions of Rule 5.1, Rule 7 of the 2010 rules, what logically emerges is that before according approval to the recommendation of the governing body and before issuing the order of appointment, the director should satisfy himself that the selection and recommendation was carried out in accordance with law. He should satisfy himself that in respect of posts like that of the principal for the UGC has laid down detailed eligibility norms and recommended or selected candidate conforms of such norms. The court in so and so has held that issuance of appointment order by a director is not an empty formality. The director of higher education before passing such order is required to scrutinize the selection record, and only after being satisfied he is issued a consequent appointment order. This is the findings of the Honorable Court that Lordship, director himself have to satisfy that particular selection or recommendation was done, Lordship, as per provisions of the rules, regulation, Lordship, forced at that point of time, Lordship, before issuing appointment letter, Lordship. Lordship, I can carry on. I have another 10 minutes I have required. So Lordship may any day, another 10 minutes.
Tomorrow it's quite late now.
Tomorrow may be difficult. Tomorrow may be difficult.
We have to.
I will take only 10 minutes, Lordship. 10 minutes. I will just refer my Lord judgment, Lordship.
Bora also is there, no?
Yes, sir. The college also.
Are you submitting or you are not submitting?
Of the director,
Okay, heard KK Manda, then senior counsel assisted by Mr. Higher.
Lordship.
Higher education and when do you want?
Next week, Lordship, any day next week, if Lordship.
Lordship's convenience, otherwise day after tomorrow also for half an hour. This can be.
Day after tomorrow, Lordship, I am some DP. I have to part-hard matters, Lordship. So some problem will arise from my side. So Lordship may next week, any day, Lordship.
On a hearing day will be.
Lordship may on 23rd. 23rd
23rd is day after tomorrow.
Yeah, sorry, the Lordship. I have forgot, Lordship. Then Lordship on 2 Lordship.
28.
28 Lordship, 28. 28 আপনি আছেন স্যার? 28 ঠিক আছে 28 oblige Lordship.
Items 19.
Oblige. It will come as a part of my lord.
Yeah, as
in your
part-
above
as
the
part-
list, yes.
Oh, yes, Chaudhary.
No problem. 19 and 21. Can it be on 14th of March?
Okay.
In between, I am traveling a little bit
On request made by IHO, senior counsel.
in both the cases.
List the matter on 19th.
14th of March.
14th.
It's a hearing day.
On 14th. So this 19 and
21
21.
March.
My lord, item number 22 can be on 9th of March, my lord. Item number 22, part-hard matter. 9th of March, my lord.
Yeah, Mr.
What is my lord? For the brief.
Request made by a Bhattacharya. The matter on when?
9th of March, my lord.
9th of March, I think there will be some difficulty.
I confirm the
there'll be some difficulty. I know it.
Then 14 of March, then 14.
My lord, item number 20, my lord, your lordship has
Yeah,
heard in
this
part.
is- this
My lord,
is-
only part of Mr. Borpujari was about to
Where
submit.
Borpujari?
My lord, he's in court number 19, he's on leg. My lord. So, my lord, any shortest date, if your lordship want to hear his part. and the-
Anytime, when do you want?
My lord, can it be on Thursday, if I may pray, my lord?
Thursday.
It's too short, but.
You are Mr.
H. Betala, my lord.
Yes, Betala, the council for police. Mr. Matter of 23rd.
Good. Highly obliged.
Which is in the rules. Success.